The stream is starting, I believe, and then we're not on the record yet, but this is the appeal of Alere Home Monitoring Incorporated, the rehearing, OTA case number 250923258. Good morning and welcome to the Office of Tax Appeals, or OTA for short. My name is Andrew Wong and I'm the lead member of the OTA panel that will be rehearing this case. On today's panel, in addition to myself, we have administrative law judges Greg Turner and Keith Long. Before we go on the record, I would like to cover a few general matters. OTA is live streaming and recording this hearing and will make the video recording available on its YouTube channel. As a result, please be mindful of any personal, confidential, or sensitive information that you might share or display. Also, from this video recording, a hearing reporter will prepare an official hearing transcript, which OTA will make available on its website. To help make a clear record, I have 4 requests of the parties. Number 1, please speak slowly, clearly, and directly into your microphone. Number 2, please do not speak over each other or interrupt when someone else is speaking. Number 3, please answer verbally using words, no nodding of the head or shaking of the head, please. Number 4, please mute your microphones when not speaking. And there's a light on your microphone. Green means it's on, red means it's off. This oral hearing is taking place before OTA, which is a separate state agency from the California Department of Tax and Fee Administration, or CDTFA. OTA is not a court, but an independent appeals body. It is staffed by tax experts and is independent of the state's tax agencies. As I noted earlier, I'm the lead panel member for purposes of conducting this oral hearing. However, my 2 co-panelists and I are co-equal decision makers and may ask questions of either party during the hearing. Our 3-person panel will decide all the issues presented to us, and each of us will have an equal vote in making those decisions. Okay, let us go on the record. This is the rehearing in the appeal of Alere Home Monitoring Incorporated before the Office of Tax Appeals, OTA case number 250923258. It is Wednesday, August 19th, 2026, and the time is 9:01 a.m. We are holding this hearing in Sacramento, California. I'm Andrew Wong, the lead member of the 3-member panel hearing this case, and with me are administrative law judges Greg Turner and Keith Long. Let us have the parties introduce themselves, beginning with the appellant. Could you please?
Good morning, Joe Vinatieri on behalf of appellant, Alere Home Monitoring.
Good morning.
And my name is Leighton Anderson, also on behalf of Alere Home Monitoring.
Good morning. CDTFA?
Amanda Jacobs, attorney with the California Department of Tax and Fee Administration.
Chad Backus, attorney with CDTFA.
Jason Parker, Chief of Headquarters Operations Bureau with CDTFA.
Good morning. All right, let us go over a few matters, including the issues that will be decided, exhibits, objections, witnesses, time allocation, and whatnot. And so there are the 2 main issues in this case and then a few sub-issues that I asked the parties to address. The 2 issues are whether OTA properly granted a rehearing, and the second issue is, if so, whether the measure of unreported inventory withdrawals of testing supplies during the liability period should be reduced, thereby entitling appellant to a refund. Appellant, does that sound like an accurate description or summary of the issues?
It comes right out of the pre-hearing conference order, Your Honor. Yes, thank you.
Thank you. CDTFA?
That sounds correct. Thank you.
Thank you. OTA also asked the parties to address several sub-issues at today's oral hearing, and I'll just cover that. Number 1, in determining whether OTA properly granted rehearing, this goes to issue 1, what level of deference, if any, does the rehearing panel, this panel, the 3rd OTA panel involved with this case, what level of deference does it give to the opinion on petition for rehearing by the PFR panel, or panel number 2? Another sub-issue is, if OTA properly granted rehearing, if panel number 2 properly granted rehearing, what level of deference, if any, does this panel, OTA panel number 3, give to the opinion by the original panel, panel number 1? Was there any taxable, and also basically the core issue, was there any taxable use of the testing supplies in California? I had mentioned at the pre-hearing conference, when I brought these sub-issues, to offer the parties an opportunity to formally brief these sub-issues following the hearing. And I was wondering, do you want to take up that offer, or do you want to wait until the end of the hearing to give an answer? Appellant?
We can revisit it at the end of the hearing. At the present time, I don't know that any additional briefing would be needed.
Okay. And CDTFA, I know in your various briefings you've touched on it as well. Did you want to take up the offer to do that, or do you want to wait until the end?
I don't foresee the need for additional briefing, but we can revisit it at the end.
Okay. All right, let's talk about exhibits then. Appellant has identified and submitted proposed exhibits 1 through 54. Appellant, did you have any other exhibits to add?
We do not.
Okay. And CDTFA, did you have any objections to appellant's exhibits?
We do not. Thank you.
Okay. So appellant's exhibits 1 through 54 will be admitted into the record as evidence. CDTFA has identified and submitted proposed exhibits A through J as evidence. CDTFA, no other exhibits?
None, thank you.
Okay. And I do believe appellant has objections to exhibits I and J, is that correct?
That's correct.
Okay. Do you have any objections to exhibits A through H?
No, Your Honor.
Okay, so CDTFA's exhibits A through H will be admitted into the record as evidence. Could you please basically summarize your objections to exhibits I through J?
The objections are that there's never been any challenge to the factual findings of Panel 1, that the record in the matter was complete at that time. As a matter of fact, even in the department's reply brief for this hearing, they indicate that there's no factual matters in dispute. It would be remarkable, I think, to find that after all these years and prior panel hearings, that there was new evidence to be presented. The OTA has rules with regard to the discovery and presentation of new evidence. Those rules have not been complied with. In addition, under OTA rules, any new exhibit should have been submitted not later than the time of CDTFA's opening brief. And in fact, these exhibits were submitted with CDTFA's reply brief and are out of order for that reason. We also don't think that they are relevant to any issue pending on the on rehearing as identified by the rehearing panel.
Thank you. Mr. Anderson, could you, when you're speaking, my understanding is that you are coming across a little light on the stream, so if you could pull the mic closer to your mouth when speaking, I think that would be, it will help make the record, and then it'll be more clear on the stream. Okay.
I don't usually get complaints about the quality of my voice, so I will try to do that. Thank you.
And might I add that we'd like to incorporate by reference our Alere Home Monitoring's objections to exhibits I and J, which she submitted previously. Should be in the record.
Okay, thank you. CDTFA, did you have a response?
We do, thank you. Exhibits I and J are directly relevant to Issue 2, whether the measure of unreported inventory withdrawals of testing supplies should be reduced. Regulation 30607A, or D, contemplates additional evidence accompanying briefing in a granted petition for rehearing, and does not limit submission of additional evidence to only cases where the rehearing was granted on newly discovered evidence or insufficiency of evidence, as appellant had claimed in their written objections. We note without any accompanying legal authority. Also, appellant's objection to the provision of exhibits I and J as untimely pursuant to Regulation 30420A is absurd. That same subdivision contemplates the parties can continue exchanging exhibits up to 15 days before the hearing. Exhibits I and J were provided over 4 months ago They could have requested additional briefing to address their concerns, but they never did so. We also note that during the original briefing in this case, appellant submitted additional exhibits in its own reply brief dated June 8th, 2023, and in its additional brief dated November 2nd, 2023. Therefore, we respectfully request that OTA admit exhibits I and J.
Can I ask a question?
Sure. Judge Turner has a question.
Is the exhibits that are being objected to, both parties, I'm curious, is this considered or looked upon as new evidence, or is this a reflection of evidence that's been previously entered in the record?
Thank you for your question. It's a reflection of exhibits that were previously submitted. For example, the exhibits are just a summary of evidence that was, most of the evidence was already in the record. We included the information we received from appellant directly as Exhibit J.
Your Honor, I think that the description is not fully accurate in the sense that the way I understood the explanation of the exhibits in the reply brief, it was a new compilation which they said included information from the audit file, but it wasn't obvious that it only included information from the audit file or from what was previously admitted in the evidence. And Your Honor's question reminds me of another concern we have, which is there is no testimony. There's no evidence regarding how these...
Sorry, Mr. Anderson, they can't hear you on the stream. If you could speak into the mic and so that the record can pick it up when it's being transcribed. Thank you.
Thank you. Again, is that better? Maybe because I was turning the other way. As I say, there's no evidentiary description of how the exhibits were prepared or what assumptions went into the preparation of the summary. I mean, we've looked at it and can't really determine what information is being displayed or what assumptions were made when the compilation was put together. These are the kinds of things that in a normal evidentiary proceeding would be established through the testimony of the preparer, but CDTFA has elected not to call any witnesses. And again, I would simply say there are no factual disputes regarding the relevant matters that were ever identified either after Panel 1 issued its findings. At the time of the rehearing petition, this issue was solely one of law on the record that existed at that time.
Thank you for your replies.
All right. I think the panel is going to take 5 minutes to discuss the objection. So let us take a break, 5 minutes. 9:20, we'll come back. We'll go off the record. Thank you. All right, we're going to go back on the record. On the objection, we are going to take appellant's objection under advisement because the proposed, I'm popping, sorry. The proposed exhibits I and J become relevant depending on how we determine issue one. Determining how we determine issue one, then issue two becomes relevant, and I and J may be relevant to issue two. So we will make a ruling on the objection in our rehearing opinion, depending on how we decide the other issues. Appellant's exhibits A through H are admitted. Objection noted to exhibits I and J, and we will take the objection under advisement, and we will make a decision on that in our opinion. Let's move on to witnesses. The parties do not intend to call any witnesses. Just confirming that, appellant, is that correct?
Yes, that's correct.
CDTFA, is that correct?
That's correct, thank you.
Okay, and now let's talk about the time allocations. Appellant, you've asked for 90 minutes. You can divide that however you want, opening presentation and then a rebuttal and closing. CDTFA, you've asked for 45 minutes. Can do the same, opening and then a rebuttal and closing. Is there any tweaks to that time estimate? Appellant.
No, thank you.
Okay, CDTFA, 45 minutes still good for you?
We don't anticipate going longer than 45 minutes. However, we do cite to many authorities in the presentation. So if it does extend a little bit longer, we would just ask for grace to finish up what we're saying.
Okay, since this is the only hearing of the day, we do have some leeway on the back end. That's fine. Also, did the parties have basically a summary of their authorities and whatnot? Maybe we should have taken that earlier.
Yes, we do. We have a list of citations to case authority. We also have a list of proper names that we thought would be helpful. To whom should I deliver these?
That's a good question. Someone is coming up and will take those from you, and we will pass them on to the panel, as well as our hearing reporter, who will be making the transcript after this. All right. Before we turn it over to appellant, any final questions from either party? Appellant, any questions?
No, thank you, Your Honor.
CDTFA, any final questions?
No, thank you.
All right. We will turn it over to appellant for your presentation. I believe you have a PowerPoint presentation as well? Okay.
Which is what you see on the screen, Your
Perfect.
Honor,
Okay, the floor.
yes. And
So, good morning, and thank you for the opportunity to present our case. Try that again. There we go, hopefully. This has been a long and winding road. Can somebody work on that mic?
Yes, sorry, let's go off the record and see if we can get the volume.
I think there might be a sweet spot between too low and too high.
You want to try it again? There we go.
Is that, okay.
Yes, that sounds good. So,
Oh, hang on, let's go, I have to note this for the hearing reporter afterwards. Let's go back on the record. Please proceed, sorry.
okay. So for us, it's been a long and winding road. Let's just use this one here. Try this one. Okay, one more time. For us, it's been a long and winding road to get to today, which has been of great concern to our client and, of course, to us. We appreciate everyone's help today in moving this matter along. We say thank you. I do want to introduce to you from Abbott Labs, Jonathan Lee, who's sitting behind me. He's a senior manager of tax, as well as Mark Gant. He's the state tax counsel for Abbott Labs. So I appreciate the fact that they're here today. So the case has a number of significant issues, a number of them, including the plain meaning of section 6009.1. But in addition, there are other important issues and policy concerns that go beyond. And you're going to hear about them in a couple minutes. We appreciate the fact that the California Taxpayers Association came on board expressing their concerns also. And with that, I'm going to turn it over to my litigation partner, Leighton Anderson, who will be making the presentation. Thank you.
Good morning again, Your Honors. We're going to begin our presentation by identifying the subjects that the presentation will address. You'll immediately notice that this is a repetition of matters that Judge Wong already read into the record, and so I promise not to spend too much time on them. But the issues are whether OTA properly granted a rehearing, and if so, what is the measure of the unreported inventory withdrawals. In our own brief, we identified the issues in slightly different terms. We thought that the issue was whether rehearing was improvidently granted. That's essentially the same. We said that in the event that rehearing was properly granted, how, if at all, does reconsideration of the issues change the decision reached by Panel 1? That framing, the difference between the framing from the pre-hearing conference order and what we were suggesting has to do with the question of how the Panel 1 decision should be treated by this panel. Whether or not, honestly, whether or not rehearing was properly granted by the second petition for rehearing panel, which is we know as Panel 2. That question is also an issue here depending on the resolution of the first issue. Our view is that the Panel 1 decision stands. It's not in any way wiped away merely by the granting of the rehearing petition, especially since the granting of the rehearing petition was specifically on an issue of law. In addition, we want to acknowledge that the panel has had posed the questions that it posed to us. Question number 1, what deference does the rehearing panel, that is this panel, OTA Panel 3, give to the opinion on the petition for rehearing? And secondly, the question of if rehearing was properly granted, what deference does this panel give to the original panel? That's part of what I was addressing a moment ago on the issue of was there any taxable use of the testing supplies in California. The panel also had a question about reporting differences. I want to acknowledge this one as well as we answer all of the questions before us. This question was that appellant reported use tax based on the cost of testing supplies shipped directly to patients within California in 2014 and 2015, but did not report use tax on testing supplies shipped to patients located outside of California in those years. What was appellant's rationale for this difference in reporting, and did appellant report pay tax to any other state with respect to testing supplies shipped to patients in those states in 2014, 2015? We will address all of those issues in the presentation, particularly the questions asked by this panel. But we believe that the starting point goes back to the Panel 1 decision. As my partner mentioned a moment ago, it's astonishing for us to consider.
Mr. Anderson, I'm so sorry to interrupt.
I'm not loud enough again?
That's right. If you could please speak into the mic. To quote your partner from an earlier hearing, could you please swallow the mic, as it were? I think that's a sound engineer term.
I was so afraid of getting the feedback, but thank you for the guidance. I appreciate that. It is astonishing. Is this better? Yes.
Yes.
As my partner mentioned, it is astonishing for us to consider that the original hearing on the merits was held July 16, 2024. That was more than 2 years ago. We do not know whether that fact by itself is a concern for OTA, but we can just tell you that it has been a concern for Alere home monitoring. What Alere was seeking 2 years ago was a final decision on the merits. It hoped for a favorable one, but even if not, it could at least evaluate its remedies and go from there. But even in July of 2024, my partner who was here at that time, Jason DeMille, opened Alere's presentation with the words, "This case has been around for a long time." That was 2 years ago. It had been around for a long time. After all, the tax years at issues here go back to 2014 and 2015 with a question pending, and we can take that one up right now regarding 2013. The answer to the question about the payment of taxes in 2014 and 2015 for California sales, but not on supplies shipped outside of California, was answered by Exhibit 2. Already in the record, was in the record at the time of the panel 1 hearing, which is the declaration of Jonathan Lee, who, by the way, is seated in the first row behind me. This is the same declaration, by the way, that the department quotes in its reply brief at page 8, footnote 14. As Mr. Lee testified on that occasion 4 years ago, Alere paid use tax on product sales, that is lancets and strips, we have some of those here, that were shipped to patients out of state until the auditor of the previous audit for the years 2010-2012 granted a refund with respect to use tax paid on those items shipped out of state. That's paragraph 3 of the declaration. The rationale for that refund, in the auditor's view, was that the sale of lancets and strips to or for the use of out-of-state patients was non-taxable in California because the use was out of state. That was in the verification comments that are quoted in the Lee declaration. Based on those comments, Alere concluded that it need not pay sales or use tax for those transactions. Alere was then considerably surprised when it received a notice of determination in 2019 that said, in essence, well, you're wrong again. You didn't need to pay California tax on those sales in the prior audit period, but now you owe tax, interest, and penalties in this one. Those verification comments, by the way, are in the record as Exhibit 4. The verification comments said in the prior audit, through reviewing the sales data and reconciling the sales, the auditor discovered that the taxpayer reported sales tax on all product sales, whether they were shipped to a patient in California or out of state. The taxpayer was granted a refund for the tax reported on product sales that were shipped out of state. Since no major changes have occurred, auditor and taxpayer agreed to use a percentage developed from the years 2010 to 2012 and apply it to 2013, but noted that in 2014 and 2015, the taxpayer made corrections to discontinue reporting out-of-state sales as part of their taxable measure. We think that that is a complete answer to the question regarding 2013 and the difference between 2013 and 2014, 2015. We acted in reliance on written advice from the auditor. It is also important to consider that the Lee declaration and the verification comments from the subsequent audit, that's Exhibit 4, were all in the record at the time of Panel 1's decision and were considered by Panel 1 in making its decision. This was all in the record, so now we are replowing old ground. The point of the hearing 2 years ago was to consider questions like this and the relevance of those questions. And as we know, Panel 1 found on the basis of that record that the out-of-state shipments were subject to the exemption, or to exclusion, I'm sorry, subject to the exclusion of Section 6009.1. While we're on the subject, the answer to the question about other states is in the affirmative. That is, other states have widely varying sales and use tax rules, as of course the panel is aware. In at least some of those states, there's a healthcare exemption that applies. But Alere is registered to pay and does pay tax in those jurisdictions to the extent of applicable law. We also believe that the taxability or not in other jurisdictions is not relevant to the issue of how 6009.1 applies to shipments out of state for use by patients and for compensation by patients' health insurers to Alere. But there's obviously a concern for double taxation under the theory that the same transactions are subject to use tax in California. This is a good time for me to mention that Alere's shipment of testing meters and testing supplies to out-of-state patients include direct supplies to patients for their direct payment without the involvement of a third-party payer. It is undisputed that shipments to those patients, if they reside out of state, are not taxable. Inventory withdrawals for supplies to those patients have always been excluded from the appeal since CDTFA admits that those shipments of supplies represent non-taxable sales. But the question of how Revenue and Taxation Code 6009.1 applies to shipments out of state for compensation by the patient's health insurers was the issue before the OTA panel, Panel 1, in 2024. Your Honor, Your Honors, that panel reached a unanimous decision on a complete record. Panel 1 did so on the basis of careful reasoning, carefully explained. Earlier, I expressed astonishment for the amount of time that has transpired since 2013 to 2015 to get to today. But the single most astonishing thing about this case is that from beginning to end is the failure of OTA to give full faith and credit to a properly constituted panel of well-qualified ALJs who exercise their quasi-judicial authority to reach a reasoned decision according to the law. I would like to add to the list of things that should concern you then as we consider what is at stake today. When we were asked, what deference should you, Panel 3, give to the previous petition for rehearing panel, Panel 2? We have an answer for that question as promised, but at the pre-hearing conference, I suggested you also consider what deference did that panel owe to the first panel? Because it was Panel 2's complete absence of deference for a co-equal panel of ALJs that leads directly to today's hearing. Because there is nothing erroneous or contrary to law about Panel 1's decision. Litigants do not always agree with the decision handed down from the bench. It's inevitable that one side will be dissatisfied, and sometimes it's even both. But final decisions should be final decisions. From the outset of Alere's appeal, the department took the position that the relevant code provision, 6009.1, does not mean what it plainly says. Revenue and Taxation Code 6009.1 provides that storage and use do not include the keeping, retaining, or exercising any right or power over tangible personal property for the purpose of subsequently transporting it outside the state for use thereafter outside the state. Despite 609.1's clarity, a brief submitted by CDTFA prior to the Panel 1 hearing, this was the department's additional brief dated August 11, 2023, asserted that the exclusion provided by 6009.1 only applies to circumstances where a person purchases property for resale, stores it in California, and then transports it outside of California for that person's use. The words "that person" were italicized to make sure that you wouldn't miss the point that it's only when a person ships it outside for their own use. That was the argument. For that conclusion to be accepted, the statute itself would have to express or apply a limitation to that person's own use, and the statute simply does not do so. It is actually nonsensical to try to find that narrow of an approach in the statute. Yet the department identified that as its long-standing interpretation, and I promise I will come back to that in a moment. But the same brief on the same page acknowledged that Alere disagreed with the own use interpretation. The brief argued, well, even with the disagreement, the same conclusion applies for a different reason. The department independently, secondarily, argued that Alere owes the tax whether or not they're being shipped on the lancets and strips, whether or not they're being transported for the patient's use rather than Alere's use, if the shipment itself constitutes some use of the supplies within California. From Alere's point of view, this is the crux of the matter. The department had in other words, the department had two distinct lines of argument at the Panel 1 hearing, one of which was based on the backup letter to annotation 280.0390, dated January 8, 1992, and I just call that the 1992 annotation. So their first argument was based on the backup letter to the 1992 annotation. That was the one that purported to limit 6009.1 to the purchaser's, quote, own use, unquote, outside of California. The other line of argument was independent of that supposed interpretation of 6009.1, but it was claimed to be supported by the 1995 annotation 570.0435, dated May 19, 1995. And again, I'll call that the 1995 annotation so I don't have to keep repeating the numbers. Distinguishing between those two lines of argument is important for several reasons, including the fact by the time we get to the Panel 2 rehearing opinion, the argument based on the backup letter to the 1992 annotation disappears. The sole focus is the one based on the 1995 annotation. But before Panel 1, consisting of Judges Brown, Lambert, and Ridnour, a hearing was conducted on an evidentiary record of the 50 exhibits submitted by Alere and another 8 submitted by the department. That was the party's opportunity to submit evidence, Your Honors. After a lengthy hearing, after considering all of the evidence, the panel unanimously adopted factual findings that are still not in dispute. No one disputes the fact findings of Panel 1 that Panel 1 reached on its record, including a statement in the department's reply brief that there's no factual issues in dispute. The only issue is the issue of law. They reach a series of factual findings that are laid out in detail in the opinion, including, number one, that Alere is a provider of at-home blood tests. I'm summarizing a little bit. INR blood tests that appellant provides to patients using a certain drug, warfarin patients with electronic testing devices and referred to as meters, and supplies consisting of test strips. We had these at the hearing previously. And we'll just, so the meter looks like this. The lancets, and they, hand me the red one. This is the old style, this is the new style. It's what the patient uses to prick the patient's finger to draw the drop of blood that the patient then places onto the strip with a little chip embossed into the strip, and then puts this strip with the patient's blood into the meter for analysis and for transmittal to the patient's doctor. You see that picture on the screen as well. So but fact finding number one from panel one was that appellant Alere provides these provider, not user, provider of these strips, the lancets and strips to be used with the meters with a doctor's prescription, training from a registered nurse as required before the test can be used independently. Finding number two, in connection with the use of the blood tests, Alere provides anticoagulation monitoring and management services. Patients relay, this is what the patients do, patients relay test results to Alere, which Alere records in its Alere Coag Clinic data management system. Alere Coag Clinic allows patients to track anticoagulation treatment, analyze test results, and adjust medication based on the automatic results reported by the clinic. Your Honors, it bears emphasis that from the patient's point of view, this is life or death. The drug can be deadly to them if it's misused or if it creates a reaction in the body that's different from what is needed for a proper for blood to coagulate. This is a blood thinner, but you need some coagulation in order to function, in order to live. And all of this is managed by physicians using the sophisticated technology for the benefit of the patient, and the patient is the key to it because it's the patient sitting in their home that's pricking the finger, putting it on the strip, inserting it into the meter, sending it to the doctor. It's also worth pointing out that this is not unlike similar procedures that diabetic patients use. Finding three, appellant purchases the supplies ex-tax, withdraws them from resale inventory, and ships them along with meters via common carriers to patients. Appellant retains titles to the meters, which are returned to appellant when the patients no longer need them. Application of tax to the sale or use of meters is not at issue in this appeal. The transactions at issue are limited to out-of-state Medicare transactions. Again, not to commercial commercial insurance transactions, not to self-pay transactions. And that Alere's compensation for these transactions comes solely from Medicare Part B insurance. Finding five. During the liability period, Alere withdrew supplies from resale inventory to ship the supplies directly to patients, The patients used the supplies for blood testing in connection with Alere's anticoagulation monitoring and management services, which is the use for which the supplies in question were designed. Those factual findings have not been challenged and should be regarded as established. Even CDTFA's reply brief, I've said this a couple of times, states that the facts are not in dispute. The only questions are how should California law apply to those facts. It is very clear from the record that the three-judge panel, Panel 1, unanimously reached legal conclusions that were carefully considered in the course of a reasoned decision. To demonstrate how Panel 1 got it right, I want to go back to the transcript of that hearing, and I want to go back to CDTFA's own summary of its argument. Beginning at about page 50 of the transcript, CDA summarized its argument by saying, appellant did not charge patients directly for the supplies and used common carriers to deliver the testing supplies to the patients out of state. Thus, CDTFA argued, Alere was the consumer, not the retailer of the testing supplies that it used in rendering its service. They said, thus, taxable use may include the withdrawal of TPP from inventory and transfer of that TTP to other persons such as common carriers in transactions that do not constitute sales, citing the 1995 annotation and also referencing California UCC 2401. This was entirely the transfer of title argument. It is evidence that the whole weight of the argument at that time was on the mere delivery of the supplies to common carriers. The reference to the Commercial Code, Section 2401, also known as UCC 2401, is to a section that concerns transfer of title. As Ms. Jacobs explained at that time, appellant made taxable use when it withdrew the supplies and shipped them via a common carrier to Medicare patients. She admitted that Alere retained title to the meters. She said after shipping the testing supplies, appellant relinquished title and possession to those testing supplies, which were then consumed by Alere in rendering its services. So I want to note that, again, we see CDTFA abandoning reliance on the 1992 annotation. It's entirely the 1995 transfer of title approach that they're focused on. Because if as CDTFA already argued, the supplies were for Alere's use out of state, then the logic of the backup letter to the 1992 annotation was that 6009.1 applied. To make the argument that CDTFA presented at the Panel 1 hearing, which was that Alere uses supplies out of state, CDTFA needed the panel to forget any mention of the 1992 backup letter. Accordingly, CDTFA's summary relied entirely on one, a theory of Alere's use, and two, of shipment via common carrier. CDTFA said, to summarize, appellant was the consumer, not the retailer of the testing supplies it used in rendering its blood monitoring services, and its withdrawal from inventory and shipment of the testing supplies via common carrier to trainers and patients outside California was a taxable use. So please note that the claimed distinction between the meters versus the taxability of the supplies, the argument was that Alere consumed the supplies when shipped. Those are the lancets that the patients use to prick their fingers, and the strips that the patients inserted into the meters so that the blood test information, that's the blood of the patients, not Alere home monitoring, the blood of the patients, could be transmitted to the patient's physicians to maintain the health of their patients, those supplies. The distinction was that the department said, well, the meters get returned eventually, but when the patients are drawing their own blood and testing their own blood and sending the results electronically through meters to doctors, that's Alere consuming its supplies. If that sounds odd, we agree. But look again at the words that we quoted. After shipping the testing supplies, appellant, meaning Alere, relinquished title and possession to those supplies which were then consumed by Alere in rendering its services. Alere was claimed to be the consumer of the supplies merely based on the fact of shipment. But what Revenue and Taxation Code 6009.1 tells us, tells CDTFA, tells the OTA, tells the world, is that use does not include exercising any right or power over tangible personal property, including handing it over to a carrier, if it's for the purpose of subsequently transporting it out of state for use, actual use, thereafter, outside of the state, which is exactly what Alere was doing when it, quote, shipped the supplies directly to patients outside of California, quoting from finding number 5. That conclusion is mandated by the plain meaning of 6009.1 itself. Shipment is not use. That is explicitly in the statute. At the hearing, Judge Brown initially asked about the first line of argument, which was that 6009.1 only applies to tangible personal property shipped out of state for the purchaser's own use. Judge Brown asked whether that interpretation had any basis other than the backup letter to the 1992 annotation. Judge Brown said, okay, I believe this is the one that says that the exclusion applies only when the person transports the tangible personal property outside California solely for that person's own use. Ms. Jacobs said, correct. Judge Brown said, and that was the part of what CDTFA relied on in its finding that 6009.1 doesn't apply. And so my question is, Judge Brown asked, do you know what that interpretation is based on? Like, is there anything to support that other than the backup letter? And it's not even in the annotation itself, I will note, it's in the backup letter. So then Mr. Backus said there isn't a specific statute or regulation that supports that. That's been the department's interpretation for several decades. And the backup letter to 570.0435, the also references in 1995 that had been the longstanding interpretation for 40 years at that point, so now going on to 70 years. So the department uses that interpretation and has used it for almost 70 years, but we are not aware of any specific statute or regulation or case law that is based on. That was clearly an admission that the interpretation does not really apply the statute because the statute clearly does not say any such thing. But even at the time, the department was putting more weight on the transfer of title when delivered to a common carrier argument. It is still worth mentioning that to this day, the department is not aware of any specific statute or regulation or case law that the interpretation is based on. It also seems worth mentioning that even the author of the backup letter to the 1992 annotation did not try to justify the underlying statement in his letter with any supporting reasoning. What I mean is, take a good look at the backup letter to the 1992 annotation. It certainly does state that 6009.1 applies to circumstances where a person purchased property outside California, stores it in California, and then transports it outside of California for that person's use. But it does not state that 6009.1 only applies in that narrow circumstance. Not at all. In fact, the letter goes on to consider a different hypothetical. The letter says, on the other hand, if the petitioner transferred the property outside California in its own facilities and passed title to the donee outside California, the petitioner would not have been regarded as making a taxable use of the property in California. Rather, such a transaction would have been one that did qualify under 6009.1.
that is, petitioner storage and transporting the property outside California, would have been excluded from the definition of use, since petitioner would thereafter use the property solely outside of California by way of transfer of title to the donee outside of California. Although the case before you, our case, is still not a gift case, that hypothetical from the same backup letter comes very close to establishing Alere's argument here. Maybe it even hits the nail on the head. If the donated property is transferred outside California with transfer of title occurring there, then the 6009.1 exclusion applies. That's the backup letter. So Judge Lambert asked about that at the hearing. He asked, in the backup letter for the 1992 annotation, there's an example that says, and it quotes the same language, on the other hand, if petitioner transported the property outside of California in its own facilities and passed title to the donee outside of California, the petitioner would not have been regarded as making a taxable use for the property in California. So Judge Lambert said, so it seems like that is a situation where the property was used outside of California by someone other than the person's use. And I'm wondering, maybe to clarify that, or is that inconsistent at all? So in response to that, Ms. Jacobs said, well, so we're saying that when the title passed, they transported it to the common carrier within California, and the backup we have for that. And there's a history of title and possession being transferred in sales, and there's also in use tax situations when someone like appellant would transfer it to the common carrier for use by another individual. That's when title passes, when it's transferred to the common carrier. In thinking about this, I've reduced the department's argument to a formula. So I've put it on the blackboard that you see on the slide. That's just me, but but you can see the equation, reducing to equation, the passage of title in California equals use in California. That's the department's whole argument. That's exactly what they are arguing. Ms. Jacobs argued that the problem with the backup letter would be avoided. This is in response to Judge Lambert's question. She argued that issue with the backup letter would be avoided as long as you can say the title passage occurs in California, which is based on an argument based on the 1995 annotation, not the 1992 annotation. But, Your Honors, the fatal defect in that equation is while that might make sense for donated property, it makes no sense at all for property provided for compensation, especially in the delivery of services. It makes no sense for property that will not be used until delivered to the actual user in Connecticut or Kansas or Oregon or wherever that actual user happens to be. Because what the legislature tells us in 6009.1 with perfect clarity is that use does not include exercising any, underscore any, right or power over tangible personal property, and that includes the right or power to deliver title, for the purpose of subsequently transporting it outside the state for use thereafter, solely outside the state, which was exactly what Alere was doing when it shipped the supplies directly to patients outside of California. That's finding number 5. It is as clear as it can possibly be that merely delivering property to common carriers for shipment to patients outside of California is exactly what 6009.1 excludes from the meaning of use. For the department or even a panel of OTA to turn around and say, oh no, When you printed a shipping label, that was enough of a use to justify taxation that directly contradicts the express mandate of 6009.1. So that's exactly what Panel 1 found on the factual record before it. Panel 1 said that Alere's use of the supplies consisted entirely of removing the supplies from resale inventory for out-of-state shipment. Thus, the property had no functional purpose in California other than as an object in transit, and subsequently is excluded from tax pursuant to Revenue Tax Code Section 6009.1. That's what they held. It was not a legal error, can't possibly be a legal error. It was a decision on the merits by a duly constituted panel of OTA administrative law judges. Now, I get it. At this point, our friends at the department, and I've met them this morning, and I consider them friends, our friends at the department respond with the words, "Long-standing interpretation." This is our long-standing interpretation, our friends say, and should not be taken away from us from some panel of ALJs. I think it's fair to say that is literally why we are here today. Reduced to its essence, that is what the Panel 2 decision says as well. So let me address that right now. The shortest answer to that argument is that no matter how long-standing an agency interpretation is, if it's contrary to the directly applicable legislative enactment, it simply cannot stand. Period. That's the short answer. Another answer is that we're not, in fact, talking about the long-standing interpretation. The annotations at issue concern the completion of a donation, a gift, the delivery of possession without consideration. In terms of 6009.1, the completion of a donation in California is not made for the purpose of transporting the donated item out of state for either the donor's or the donee's use. It's made for the purposes of the donation itself. So there's a rationale, and of course case law too, for the idea that a donation of property is the donor's use of that property where the donation occurs. The backup letter previously quoted concluded that if the donation applies outside the state, after the property is transported out of state, then 6009.1 would apply. That too is a long-standing interpretation. It's in the backup letter from the 1992 annotation. In addition, the long-standing interpretation argument never mentions, this omission screams at us, never mentions CDTFA's own regulation 1620. Regulation 1620, subdivision B9, restates 6009.1 verbatim without including anything at all like the longstanding interpretation claimed by CDTFA. In Regulation 1620, in giving examples of when the exclusion does or does not apply, the regulation says, for example, an engine transported outside the state and installed on an aircraft which does not return to the state qualifies for the exclusion. Nothing there considers whether the transportation would be by a common carrier or would involve transfer of title to the aircraft owner. It simply says that transporting the component part out of the state for out-of-state use qualifies for the exclusion. The general rule for use tax under Regulation 1620 is simply that use tax does not apply to the use of property held or stored in this state for sale in the regular course of business, nor to the use of property held for the purposes designated in subparagraph B9, those purposes being for the purpose of transporting it out of state, quoting 6009.1 verbatim. CDTFA has no other interpretation of that provision, long-standing or otherwise. CDTFA can no more decide to disregard its own regulation than it can decide to do so with a legislative enactment. Regulation 1620 also states, for purposes of this regulation, functional use means use for the purposes for which the property was designed. In the case of the lancet, that's used by the patient when they take the needle and they stick it into their finger and they draw blood and they put it on the strip and they put the strip into the meter and send that to their physicians for purposes of maintaining their own health. That is the functional use for which that property was designed, and that's defined as functional use in Regulation 1620. Under the regulation, the location of the first functional use determines the place at which the use of the TPP first occurs. CDT has no other interpretation, longstanding or otherwise. Now, just to keep my presentation organized, we've been considered the reasons why that formula, PTCA equals UCA, possession of title, transfer of title in California equals use in California, does not work. It's been central to the department's argument all along. But what I said a few minutes ago is while it might make some sense for donated property for gifts, it makes no sense at all for property provided for compensation, which will not be used until delivered to the actual user in Connecticut or Kansas or Oregon or anywhere else. And 6009.1 is just very, very clear that use cannot be based merely on the act of shipping the tangible personal property out of state, which is all we have in this case. I need to come back to that now to correct a misunderstanding about the difference between gift and non-gift transactions and what that means for the location of use. That is why the analysis of Yamaha 2, and I'm going to be referring to these cases by name without providing for the record a full citation, but I assume that's why we have the list of citations that we provided to the panel. In Yamaha 2, the issue was specifically, when is a gift made for purposes of determining if a use tax is due? That's page 357 of the published opinion. Yamaha 2 was decided after the California Supreme Court in Yamaha 1 had made important rulings regarding the weight, if at all, to be assigned to annotations and the like. The court's decision on remand, Yamaha 2, was strictly limited to the gift issue. Yamaha 2 said that even a constructive or symbolic delivery is sufficient to vest title in the donee as long as the evidence clearly shows an intent to part presently with some substantial attribute of ownership. But what is true in a gift context is not true in a sale of goods context. In a transactional setting, with or without a third-party payer, the time and place of transfer of title is based on the agreement of the parties. That agreement can be explicit or implied from the circumstances. When the department, way back at the time of the panel 1 hearing, when the department in the transcript at pages 50 to 51 referred to the California Uniform Commercial Code 2401, it was citing the UCC provision regarding transfer of title. Under subdivision 2B of section 2401, quote, if the contract requires delivery at destination, title passes on tender there. In the representative contract that's in the record as Exhibit 18, lancets and strips are required to be delivered to the user's home. That is a reference to Exhibit B within the representative agreement. So if you look at Exhibit 18, you find Exhibit B, and it says that lancers and strips are required to be delivered to the user's home. The structure of the agreement demonstrates clearly that the lancets and strips are not delivered and paid for until the patients use them. That could be in any state of the United States. There is no other theory of title passage that fits these facts. Finally, the department's arguments about its supposed longstanding interpretations are contradicted by the California Supreme Court's decision in Yamaha 1. Annotations do not have the force or effect of law and are entitled to little deference on matters of statutory interpretation. The idea that the subtext or implication of backup letters and the like can acquire special status through the passage of time was specifically rejected by the California Supreme Court's majority opinion. Moreover, the department's effort to derive a legal rule of general application from the penumbra, as it were, of various annotations or opinions would amount to an informal regulation of the kind forbidden by the Administrative Procedure Act. Let me make sure that that's clear. The department says, well, we're just relying on annotations. We've had these annotations for a long time, but the annotations, number one, conflict with the Regulation 1620 as well as the statute. But number two, they're specifically designed and intended for use in the donation context. The department is going beyond the donation context in trying to export a concept relating to transfer of title from gifts, from donations into commercial transactions. That effort isn't documented anywhere, and it certainly doesn't meet the standards required for a rule of general application under the Administrative Procedure Act. That's what makes that interpretation to that extent an underground regulation, and the amicus brief from California Taxpayers Association, we think brought that out pretty clearly. We also adopt that argument for purposes today, for our purposes today. For the department to insist that a rule of general application can be found by peering into multiple annotations and letters over the years is simply the confession of its attempt to adopt a rule without troubling to comply with the Administrative Procedure Act. Accordingly, when Panel 1 decision was issued, it made specific evidentiary findings and then applied those findings to the department's made contention. First of all, the Panel 1 decision acknowledged that the department's reliance on the 1995 annotation and the backup letter to the 1992 annotation as support for its contention that Alere made a taxable use of the supplies at issue when Alere withdrew the supplies from resale industry and shipped those supplies via common carrier to Medicare patients and trainers pursuant to its contracts. The Panel 1 decision said that was inconsistent with the controlling provision of law, section 6009.1. Such claimed uses could not be a taxable use since such a conclusion was ruled out by 6009.1's express provisions. Second, the decision further noted the absence of any authority for the concept that out-of-state transport pursuant to a contractual requirement constitutes a functional use in and of itself. Moreover, the department held that the department's reasoning is inconsistent with its treatment of Alere's out-of-state transport of meters, which also fulfilled a contractual obligation. Third, Panel 1 again cited the 1995 annotation with respect to whether title passage could be a determinative factor under 6009.1. Panel 1 ruled that such an argument appears contrary to California case law, which sets forth that the applicability of section 6009.1 is contingent on the purchaser's physical use of the property. Fourth, the panel similarly found an absence of authority supporting the position that 6009.1 only applies when the purchaser uses the property outside of California, and that the department's interpretation was inconsistent with case law such as Stockton-Kenworth, which found that 6009.1 applied to a lessor's transportation of trucks driven without payload to lessees in other states. Fifth, and again returning to the backup letter to the 1992 annotation, Panel 1 observed that the department's position that 6009.1 is limited to situations in which the purchaser transports property out of California for the purchaser's own use was not even in accord with the entire backup letter, and we've established that point earlier today. Your Honors, that decision was issued in October 2024, nearly 2 years ago. It should have been the end of the matter. That decision was thorough, well-considered, and supported by substantial evidence. Indeed, it was supported by the weight of the evidence. The decision applied the law as the administrative law judges of this agency are asked and required to do. Alere, for its part, devoted enormous internal resources, as well as engaging the services of counsel, in the expectation of one of two outcomes. Either Alere would prevail, or it could and would then consider what judicial remedies, if any, it could pursue. What happened instead is that CDTFA asked for a do-over. We acknowledge, of course, that OTA has a rehearing rule that carried over in a substantially equivalent way from the Board of Equalization era for sales and use tax cases. Based on our experience here, we think that OTA should consider revising the rule to better suit an agency of many co-equal and collegial administrative law judges versus the former format of adjudicative hearings by a single elected Board of Equalization. That is, a rule designed to allow the Board of Equalization to reconsider its own decisions is not well suited to an agency of many ALJs in which there could be a potential for forum shopping. The rule is capable of being misused when a party, especially the one that is regularly appearing before the agency, has an opportunity to overturn one panel's decision by asking another panel to do so, unless there are strong built-in safeguards to prevent such misuse. In the case of the current rule, and of course we're under the current rule, I understand that, some safeguards do exist. It is those safeguards on which Alere is relying today. I will turn my attention to them now, but we also believe that the agency should consider strengthening them. In different circumstances, we do not believe that it would have cost Alere the last 2 years to preserve the result of an appeal in which OTA had already ruled in Alere's favor. After panel 1 issued its decision, the department filed a petition for rehearing. We know that, that's obvious, in which the department asserted the panel 1 decision was contrary to law within the scope of Regulation 30605A5. The petition for rehearing was filed on November 18, 2024. The petition for rehearing asserted that the contrary to law standard was met because it alleged the panel 1 decision is in direct conflict with precedential case law, and the decision was also inconsistent with the department's longstanding interpretation of 6009.1, which is entitled to great weight. Fully 10 months later, Panel 2 issued its decision granting the PFR, 10 months later, on the sole ground that the Panel 1 decision was contrary to law. Despite reaching that conclusion, Panel 2 acknowledged that Panel 1 considered the 1995 annotation, as well as the department's longstanding interpretation that title passage in California constitutes a taxable use, but stated that Panel 1's grounds for disregarding the 1995 annotation are problematic. Problematic and error of law are two different things. But Panel 2 found an absence of authority for the physical use standard and cited Yamaha 2 on the issue of when and where gifts of promotional materials and the like are made for purposes of determining if a use tax is due. The question to be asked again is, did that really amount to an error of law? The answer must be no. There's also the question that was asked of us, namely, what degree of deference is owed to the Panel 2 decision that held the other way? Consistent with my promise to answer that question, I will take it up now. While the OTA's rules of procedure allow for petitions for rehearing, they do not allow for such petitions to be granted on grounds other than those provided in Rule 30604. In this case, the sole basis for rehearing was asserted in the Panel 2 decision to be the ground provided by Subdivision A5 that the opinion is contrary to law. Such a finding must be based on the determination that the decision on a material point was clearly inconsistent with the applicable law. As stated in Appeal of Rydell, a 2024 OTA decision, the contrary of law standard of review shall involve a review of the opinion for consistency with the law. The question of whether the opinion is contrary to law is not one which involves a weighing of the evidence, but instead requires a finding that the opinion is unsupported by any substantial evidence, that is, that the record would justify a directed verdict against the prevailing party. This requires a review of the opinion in the manner most favorable to the prevailing party, and indulging all legitimate and reasonable inferences to uphold the opinion if possible. The question before OTA on a petition for rehearing does not involve examining the quality or nature of the reasoning behind OTA's original opinion, but whether that opinion can be valid according to the law. So the rule specifies what does and does not constitute grounds for rehearing, and existing OTA precedent applies those rules. As stated in a non-precedential decision, this is Starbuzz International case in 2023, a petition for rehearing case. OTA's rule in a petition for rehearing is not one in which a new panel can reevaluate the underlying appeal. The majority of the PFR panel relied on their interpretation of the Revenue Tax Code section at issue when determining whether or not the opinion was contrary to law. Therefore, the PFR panel made an error in granting the PFR. That's the standard that should apply here as well. Despite our citation of the applicable rule in prior OTA decisions, the department's sole response to this point has been to assert that panel 2 had wide discretion, the exact words, in ordering rehearing, and that the exercise of its discretion should be accorded great deference. That is simply an indefensible argument and one that renders important procedural protections unenforceable. The panel should reject those arguments on multiple grounds. First, an agency does not have wide discretion or any discretion to disregard its own rules. A public entity has a ministerial duty to comply with its own rules and regulations where they are valid and unambiguous. We cite for that Gregory versus State Board of Control, a 1993 case. It's in the list we provided to you. Whether adjudicative proceedings are conducted in accordance with the APA or this agency's own rules, those rules cannot be disregarded or set aside without formally amending or changing the rule. And we cited Malaga County Water District versus Central Valley Regional Water Quality Control Board, a 2020 case. The same underground regulation violation that we were talking about earlier arises when an agency informally adopts policies like, a panel has wide discretion to just overturn a prior panel's decision. If an agency informally adopts a policy like that that is at variance with its own rules, that's an underground regulation. In other words, neither OTA nor any constituent panel may disregard the grounds and standards specified in the rehearing rule by claiming that it has wide discretion to do so. Instead, the department's theory that the rehearing rule somehow granted the same discretion to panel 2 that a trial judge in Superior Court would have in granting a new trial motion under Code of Civil Procedures Section 657 would, if adopted, add a gloss to the rehearing rule that would compromise procedural fairness by incentivizing post-decision forum shopping and constitute yet another underground regulation. Moreover, Department's reliance on Code of Civil Procedure Section 657 is seriously misplaced for another reason. A trial judge does not have wide discretion or any discretion at all to grant a new trial based on an error of law if no such error can be found. We cited Pomona Valley Hospital Medical Center versus Kaiser Foundation Health Plan, a 2026 case, and Ramirez versus USAA Casual Insurance Company, a 1991 case. The courts declare that where a new trial is granted on the basis of legal error, we must first determine whether the ruling of the trial court that the trial court claims was made in error is a matter of law, as a matter of law, truly error. Again, that's Pomona Valley, the Pomona Valley case quoting Donlen, D-O-N-L-E-N versus Ford Motor Company, a 2013 case. Moreover, the cases say if there were no legal errors at trial, the order granting a new trial on the basis of error of law will be reversed. So if we're going to use Section 657 as an analogy, which honestly we shouldn't, the same principle of it has to be demonstrated that there's an error of law and there's no wide discretion or any discretion to do anything else is the one that would say that the Panel 2 decision should be reversed because it did not demonstrate an error of law. Instead, it disagreed with an interpretation that the previous panel had announced. In short, no discretion was vested in Panel 2's finding that the original decision was contrary to law. The issue is a legal one. If the Panel 1 decision was not contrary to law, then the Panel 2 decision was improper as itself, contrary to the rehearing rule. This panel should consider that the department has not attempted to justify the contrary to law conclusion in Panel 2's rehearing order, apart from the assertion that it had wide discretion. It is because the Panel 1 decision cannot be shown to be contrary to law. On its face, a perceived deficiency in the quote-unquote weight to be given to a non-binding agency interpretation cannot implicate the contrary to law legal standard, since the weight to be given to any interpretive authority is a matter for the adjudicative body's legal analysis of the underlying rule of law, the authority granted to the agency to adopt it, and multiple other factors, and that's what the California Supreme Court held in Yamaha 1. In addition, a fair reading of the Panel 1 decision shows that it did give consideration to the 1995 annotation. Indeed, the Panel 1 decision gave extensive consideration to the annotation and simply disagreed with it. The opinion's disagreement was expressed on a reasoned basis, stated in the opinion as fully consistent with and not contrary to the non-binding nature of the annotation, even when limited to the context of the facts on which that annotation was based. The weight to be assigned to it in any other context. Here, for example, the context is the outright transfer of tangible personal property for considerations to medical patients residing outside of California, involving the use of medical equipment for their own in-home monitoring and treatment. The weight to be assigned to the annotation necessarily required consideration of the validity of its reasoning and its consistency with earlier and later pronouncements and other factors. Again, that's Yamaha 1 at pages 14 and 15 of the published opinion. Panel 1 focused on the plain meaning of Section 6009.1 in deference to the legislative enactment, which is entitled to greater deference than the agency's apparent preference to restrict the scope and application of 6009.1. We provided an analysis of the case law on this subject in our brief, and the amicus brief of the California Taxpayers Association also provided its analysis. It is simply not the case that the hearing panel did not entertain or consider those factors. It clearly did. It is rather the case that on consideration, CDTFA's argument was found to be unpersuasive for reasons that are clearly articulated in the Panel 1 decision and on the record of the hearing itself. It follows that Panel 1 did not reach a decision on the merits that was contrary to law. Instead, it was the panel's fully justified effort to apply the binding rule of decision, which is found exclusively in Rev and Tax Code section 6009.1. No other conclusion survives even minimal scrutiny. The Panel 2 decision also asserted that Panel 1 needed to address the observation in Yamaha 2 to the effect that when a taxpayer makes a gift of property, the taxpayer has exercised its right to transfer title to the property and hence the making of a gift a use. But the Panel 1 analysis was that the shipments of testing supplies were not gifts. They were items of property being provided for compensation and for purposes of a specific intended use by the patients. That addressed the gift question to the extent needed. The rest of the analysis was simply to apply 6009.1 according to its express terms. Likewise, it seriously misstates the record to assert that Panel 1 failed to consider title passage of the supplies in California as a taxable use. To the contrary, Panel 1 considered it and reached a reasoned conclusion to the contrary. It follows that the Panel 2 decision stepped well outside the scope of Rule 30604 to a degree that violates minimal due process requirements. Our Supreme Court has long held that agencies and other public entities lack jurisdiction to act outside their authority, to grant certain kinds of relief, or to act without the occurrence of certain procedural prerequisites. That's the off-cited case of Alere, Abelleira versus District Court of Appeal, a 1941 California Supreme Court case. We also cited Buckley versus California Coastal Commission, a 1998 California Court of Appeal case. Procedural requisites include whether circumstances permitting a decision to be reopened have been met. And we cited Fireman's Fund Insurance Company, a 2010 case. Moreover, a public entity has a ministerial duty to comply with its own rules and regulations where they are valid and unambiguous. That's Gregory versus State Board of Control cited earlier. It's also CV Amalgamated LLC versus the City of Chula Vista, a 2022 Court of Appeal case. In the absence of any genuine legal error in the Panel 1 decision, OTA should recognize that it lacked jurisdiction to grant the petition for review, and it should reinstate the Panel 1 decision. Your Honors, thank you for your time and attention this morning. That completes Alere's opening statement. It is very clear on the record that Panel 1 got it right the first time. There was no error of law shown, and so rehearing should not have been granted. The last 2 years, candidly, have been a mistake that we hope you will rectify. The Panel 1 decision should stand as OTA's final decision in the case. Thank you.
Thank you, Mr. Anderson. You have about 15 minutes left for rebuttal and closing. All right, I'm going to turn to my co-panelists to see if they have any questions for appellant, beginning with Judge Turner.
If we are examining the opinion of the petition for rehearing, what's the level of deference that we are to provide that opinion relative to the one that you allege should have been provided to by that panel to the original opinion, and does it come to a different outcome? Does it result in a different outcome? Sorry.
So the first part of your question was if we are in unanimity with
No, we're reviewing the first issue is the review of the PFR
I see.
opinion.
Okay. So
Go ahead, sorry.
And so I think I was intending to address that, but let me be clear. What you should be, the level of deference is strictly one of, did Panel 2 follow the rules? Did Panel 2 correctly apply the rehearing rule from 30604 itself to 30604B, which talks about what an error of law is or isn't, what the Rydell case and what the Starbuzz case say should be done on at the time of petition for rehearing. So it's not a question of deference, it's a question of, was there an error of law or not? It's not a question of deference if there is no discretion in panel 2 to wipe out the panel 1 decision under the rehearing rule. Does that answer your question?
It just seems that that's a conclusion of law in and of itself. Making the analysis is whether or not looking at the initial facts from the first opinion in a light most favorable to the victor there, which is the taxpayers, whether there was a conclusion of law. I mean, whether there's an error of law or not, the second panel made a determination about that. And they concluded that there was. And I'm asking whether or not, in our review, are we simply reviewing that question of law again, or are we to provide some level of deference to that determination by the second panel?
So I have two answers to that. The first, the simplest, is that question, the question before you with regard to the panel 2 decision is purely a legal issue. And as a purely legal issue, it can be determined de novo in the sense that that you have to be satisfied that applying the proper standard to the rehearing petition, panel 2 made a legally justified decision in granting it. I don't think it's entitled to any deference in the sense that it is a legal issue entitled to de novo review, and I think that it is evident, and certainly the point of my presentation this morning, it's evident that the panel 2 didn't give any of the required deference to panel 1. So that, if that's evident to you, then that should answer the question.
So what I'm trying to get at is that the argument that you're making regarding the decision of the panel on the PFR, the second, we'll call it second opinion, is that they essentially stepped into the shoes of the original panel and made a determination contrary to that original panel, and that's inconsistent with the regs. That's your argument. I'm trying to get the next question up, which is, why are you not asking us to do essentially the same thing? Stepping into the shoes of the opinion number 2 panel and basically making a legal determination that their conclusion was wrong.
Well, it's the only reason it's not essentially the same thing is because we're talking about the difference between the merits of the case and the application of a procedural rule. Because I think it's true that what we're asking you to do is to understand that the rehearing rule didn't permit panel 2 to do what it did.
Okay. Second question, on the merits. You said, I think at one point, that the supply of the lancets that are at issue here are pursuant to a contract with under Medicare Part B. Did I understand that correctly?
Yes, you understood that correctly. It's a contract. It's through insurance companies, in this case Blue Shield. This is Exhibit 18 that's in the record before you. So Blue Shield and other insurance plans offer insurance that wraps around Medicare Part B, and those are the contracts that are involved, and Exhibit 18 is a representative example.
So you're essentially supplying the lancets potentially so long as the payments from Medicare are coming through for the overall service, you're essentially providing lancets to these patients indefinitely.
Yeah, there's separate pricing though for the lancets and strips, and it's payment based on the patient's actual use.
Oh, okay. Thank you. That's all the questions I have. Thank you.
Judge Long.
No questions, thank you.
Thank you.
All right, I did have a few questions. Just following up on Judge Turner's question, so the contract was between these insurance companies and appellant, is that correct?
Yes.
And so where do the patients come in? What's their relationship in this contractual? Are they like,
So the patients are insureds. So this is a third-party payment situation, and in this day and age, all of us are well aware of that kind of situation. So the patients are have insurance with a private insurance provider that wraps around their existing Medicare coverage. And that's what pays for through the Medicare system, but as mediated by the insurance company, that's what pays for the package of services that they are receiving as in relation to their consumption of the warfarin medication.
so when appellant ships the supplies, the lancets and the test strips out of state to the patients, and the patients then use them to test their blood, who is doing that use? It's the patients. It's no longer in appellant's possession, and they don't no longer have title to it, do they?
Well, so they certainly, Alere isn't consuming the lancets and strips, and so if you're concerned about title, and I understand the question, then it occurs. The transfer of title occurs at the point of delivery to the patient in their home, because that's when the payment obligation is triggered, and that's where the actual use occurs. And it can't be said, similar to a donation hypothetical, it can't be said that Alere was completely done with the lancets and strips. After all, the meters to which the lancets and strips were necessary supplies still belonged to Alere, and Alere is still at the receiving end of the data reporting that is necessary for the patient's doctors. So the lancets and strips are little pieces of this chain, but number one, it's delivery to the patient in Utah or Nevada or any state in the union. It's the delivery there that triggers that completes the contract, that triggers the payment obligation, number one. And also creates tax issues in that for Alere in those states, not issues, but taxability. Number one, and number two, that's where the first functional use occurs, and we argue under 1620 that's relevant as the place where it occurs, and it's certainly not relevant that in the meantime all Alere did was have a shipping label printed so UPS will drop it off at the destination. That's what 6009 says is not a use.
So did Alere report taxes in those other jurisdictions on the transfer of title, like use tax in these other?
I tried to address that earlier. The answer is yes.
Okay, and do you have any backup for that?
We looked into the question, but we haven't made any kind of an evidentiary presentation on it because, number one, we weren't asked to, and number two, again, I don't think it's relevant to the question of what 6009.1 permits and doesn't permit in the terms of use taxation. It should be sufficient to represent to you, and I'm happy to do so, that we do pay tax on the
Lancets on the delivery of these supplies unless there is some kind of a medical exemption for them, in which case that's the policy of the state in which the use occurs, and that state's policy ought to be respected as well.
Okay, I'm going to pause my question and turn it over to Judge Turner. He had another question.
Something you said triggered a couple things for me. One, you said that if the Lancets don't arrive, that that doesn't trigger payment. So you're telling me risk of loss was on Alere until the Lancets arrived at their destination?
I suppose that that's true, yes.
Second question. Question of annotations. We've talked about these in your presentation a couple of different times. There are two aspects to what we colloquially refer to as an annotation. One is what you might call a summary, and one might sometimes refer to as the backup. I'm trying to understand what an annotation actually is. I think under the government code, legal rulings of counsel are exempt from the Administrative Procedures Act. Which is the legal ruling of counsel, the summary or the backup, or both?
It's my understanding. It's a great question. It's my understanding that the legal statement that is annotated is considered the legal opinion of counsel, rather than the what's called the backup letter. But the other point I would have is that, number one, it's not entitled to great weight, it's entitled to limited weight, if any. That's Yamaha 1. And number two, it makes a difference. What the APA doesn't authorize, even though there's an exemption for legal rulings of counsel, I understand that. What it doesn't authorize is to take a legal concept out of that legal ruling and expand it beyond its four corners to create a more general rule that wasn't expressed in the original legal ruling. Does that?
Yep.
Okay. In the annotation.
Understood. Thank you.
Thank you.
Can we have 1 minute, please?
Sure.
My colleague is pointing to me that Exhibit 20 has the code. This is the Medicare provision that governs the payment for the supplies.
Thank you.
I'd referenced Exhibit 18, and he's saying, well, we could have referenced Exhibit 20 as well, and so I'm happy to do that.
Just another question regarding 6009.1. It uses the specific term transport. Does that have any legal significance as opposed to shipping or transferring? It says transport specifically. Does that have any specific meaning?
It strikes me that the word, any word in a statute has legal significance, but it strikes me that the word is a general term because there can be more than one kind of transport. So it's intended to generalize, shipping on a train, shipping on a truck, shipping on a ship, shipping by, giving it to Pony Express. I'm being facetious, but you know what I'm saying. There could be many different kinds of transportation involved. But what the statute says is if it's for the purpose of transporting it out of state. So that becomes, in my mind, very, very clear that if what you're doing is you're talking about, we've got it here in a warehouse, but it has to get, I just knocked into the mic, but it has to get across the border into Nevada, or it has to get to Arizona, or it has to get all the way to the East Coast somewhere. Any of that is transporting, and if that's the purpose for which it's leaving the warehouse, 6009.1 says that's not a use. Plain as day.
Okay. So they're under 6009.1, you would say it would apply if appellant had its own trucks, filled it up with supplies, and then drove it across state lines and delivered it to patients. That's equivalent to, that 6009 applies to that situation and also to the situation where it drives to the post office or UPS comes, picks up the supplies, a third party.
I would say it's indistinguishable who owns the truck or the plane or the boat or whatever it is, yes.
Okay. All right. And then, sorry, my other question goes to the first issue, talking about whether we owe any deference to Panel 2's question. What if we found that Panel 1's opinion was contrary to law, but not the law specified in Panel 2's opinion? Are we allowed to find that the right result was arrived at, but for the wrong reason, or are we kind of constrained to what was determined in Panel 2's opinion?
Thank you for asking that question, because I think the answer is important. Because we're talking about the application of procedural rules, and we're talking about procedural due process. So this case comes here today through a path that we all well know and well understand. And so it's solely before you. The question of whether or not rehearing was properly granted is whether they did the right thing on the merits for the reasons they stated, not for any reason at all, but for the reasons that they stated. And it's particularly important that they did so on the unchallenged basis of the record that had already been established by Panel 1, and that there was no challenge to any factual findings. So I would say that you are to look solely to the legal issues that Panel 2 said were the legal error in Panel 1, because if they weren't, then there's no jurisdiction under OTA's own rules as a matter of procedural due process to do anything else.
Okay, thank you. Just to follow up on that question a little bit, and I'm going to compare and contrast this case a little bit with the Starbuzz case, which you had mentioned earlier. In that case, OTA was looking at one specific statute, a definition. The first panel viewed it one way, the second panel viewed it another. The third panel says the second panel couldn't substitute their interpretation for the first panel. So just following up on my question earlier, what if we find there is Panel 1's decision was contrary to law, but the source of law is two separate sources. They said Law 1, we say, well, maybe it's not contrary to Law 1, but it is contrary to Law 2. Would we be permitted to uphold Panel 2 in that scenario?
I'm not sure that I understand your question, but let me take a shot at it, and if I haven't answered it, then please give me another chance. My understanding of what Starbuzz said is, we don't think if this was our decision to have made originally, we would have made the decision that the original panel made. Nevertheless, we think that the rule requires us to reinstate the original panel because the showing needed to overturn it is not present. That's what we think you should do today, even if you were to disagree with the original panel's decision. Does that answer your question?
Not exactly. I guess in Starbuzz, we're looking at just one piece, let's say, authority. In this case, maybe there's competing authorities. And panel two, let's assume panel two said in that the first panel got it wrong, contrary to authority one. What could we say? Well, they got it wrong, but because it's contrary to authority two.
So the OTA case law that we've referred to, the Rydell and the text of the regulation itself, make it clear that the existence of a rehearing petition didn't give panel one or this panel a general permission to reevaluate the case, to reconsider the case starting from scratch, as it were. What the rules require is that you identify, that you give every weight, every presumption to the prevailing party at panel one, that's my client. Give every weight and presumption to that and to the evidence that was established. Take that all for granted and be able to identify a clear material legal error. If you can't do that, then I think you have to stop.
Okay, but then you had mentioned there's a de novo standard. Would we be applying the de novo standard to interpretations of legal authority, legal questions?
To the extent you're reaching the merits. So, for example, maybe it seems inconsistent. I don't think it is. When you're looking at panel two's decision, you're looking to see, did they correctly identify an error of law in panel one such that it would have justified a directed verdict to the CDTFA applying the Rydell standard. I don't see how you can answer that in CDTFA's favor, and they don't even try to make that argument. But to the extent, let me be clear about this, that you're looking at the legal conclusions of panel one, if you can identify an outright legal error and find that legal error was found by panel two, then you're ruling on that de novo. But that's a pretty tough filter to get through.
Okay, thank you. And then I have one final question, but just to give a roadmap of what's going to happen after this. After panel questions, we're going to take a break, 10 to 15 minutes, and then after the break, we're going to turn it over to CDTFA for their presentation, and then rebuttals and closings, and panel questions included, and then we'll close out the hearing. But okay, so my question goes to, okay, so the contract, this goes to the merits. The contract was between appellant and insurance companies, Medicare. Alere was paid with respect to these to provide tests, services. I believe that was the finding of panel one. And then I believe they also, somewhere along the way, it was found that if services was the main object of the transaction, then the consumption of these supplies was subject to use tax by Alere. So if the contract is between appellant and the insurance companies, and Alere is giving these, not giving, they're transferring these supplies to these out-of-state patients, I mean, is that kind of analogous to like, I don't know, a drop shipping situation where the first transfer from Alere in their Livermore warehouse to an out-of-state patient through a third-party common carrier, does this touch upon any of those drop shipping principles? or it becomes the first person who, quote, uses it or transfers it in California is responsible for the tax.
Well, so but you want to say a drop shipment is a drop shipment is a sale, but
That's not what we're talking about here.
Sure.
but I still appreciate the question. I don't think that the presence of Medicare, the presence of Medicare-based insurance, should really change our understanding of the substance of this transaction. After all, there are situations where Alere sends medications or sends these things to self-pay patients, and nobody thinks that those things are taxable. The patients just pay for it. So really, the only thing that's different about this case is not it's not a structural difference in substance. It's just a question of, well, there's a third party paying for it. So no, it's not drop shipment. It's not even a third party beneficiary contract. It's just that it's in the nature of an insurance company that it stands in the shoes of its insured for purposes of payments for certain kinds of losses or risks, in this case, healthcare.
All right, thank you. All right, let's take a 10-minute break. We'll come back at 11:15. Let's go off the record. Thank you.
Before I get started, I just wanted to say that exhibit page citations during my presentation are to the PDF page numbers contained in the department's single exhibit file provided along with our pre-hearing conference statement. So it'll be to that giant single PDF we gave with our PHC statement. Okay. Appellant, Alere Home Monitoring Incorporated, provided in-home blood testing services and patient training during the liability period of January 1st, 2013 through December 31st, 2015. During the liability period, appellant operated an office and warehouse in Livermore, California, and was enrolled in the Medicare program as a fee-for-service contractor, under which appellant was classified as an independent diagnostic test facility and received payment from the U.S. government for its services. Exhibits E, pages 129 to 130 and 137, and F, page 1922. Appellant provided patients with electronic testing meters, not at issue in this appeal, as well as test strips and lancets, or collectively testing supplies, and collected and reported the test results to the patient's physicians. Exhibit E, pages 129 to 130. Appellant also contracted with registered nurse trainers who met with patients and trained them how to administer the test themselves. Exhibit E, pages 128 and 1758 to 1760. Appellant purchased the testing supplies ex-tax by using resale certificates from vendors in and outside of California, then withdrew the testing supplies from resale inventory and shipped them via common carrier to patients as part of its services. Exhibit E, pages 122, 137, 1783, and 1787. Appellant received payment based on the number of tests performed, irrespective of the quantity of supplies provided, and appellant did not directly charge trainers or patients for the testing supplies or collect sales tax reimbursement on the testing supplies. Exhibits E, page 130, and F, page 1922. Starting in 2014, appellant reported use tax on its purchase price of testing supplies shipped to patients within California, but appellant did not report use tax on the testing supplies shipped out of California. Exhibit E, page 132, and F, page 1926. During the audit, the department determined that pursuant to Revenue and Taxation Code, Section 6009, appellant's taxable use of the testing supplies occurred in California when the tangible personal property, or TPP, was transferred to a common carrier, regardless of whether the testing supplies were then shipped to patients located in or outside of California. Exhibits E, page 134, and F, page 1926. Following an audit, the department issued a notice of determination to appellant on September 26, 2019, which included a deficiency measure for unreported withdrawals of testing supplies from resale inventory, subject to use tax. Exhibits C and E. Appellant filed a petition for redetermination and ultimately appealed to OTA. OTA Panel 1 issued an opinion on October 18, 2014, what we'll call the original opinion. 2024, apologies, what we'll call the original opinion, finding appellant was entitled to a refund on the basis that the Section 6009.1 exclusion was applicable to appellant's out-of-state shipment of testing supplies. The department timely petitioned for a rehearing pursuant to Regulation 30604A5 on the basis that the original opinion is contrary to law. Specifically, that it did not give sufficient weight to the department's long-standing interpretation of Section 6009.1, that it failed to consider title passage as a taxable use pursuant to Section 6009, and that it failed to address and is in direct conflict with precedential case law. OTA Panel 2 issued an opinion on petition for rehearing, granting a new hearing, which we are at today. The first issue is whether OTA properly granted a rehearing. This panel, Panel 3, has asked the parties to address whether the rehearing was properly granted. Specifically, you have asked us to address the degree of deference Panel 3 should afford Panel 2. The law requires Panel 3 afford Panel 2's decision to grant a rehearing great deference. OTA has found that case law pertaining to California Code of Civil Procedure Section 657, which sets forth the grounds for granting a motion for new trial in a civil action, is relevant to interpreting Regulation 30604, which sets forth the grounds for granting a petition for rehearing before OTA. See Appeal of Martinez Steel Corporation, 2020-OTA-074P. According to the case, City of Los Angeles v. Decker, 1977, 18 Cal 3D 860, pin site 871 to 872, because OTA is the body of original jurisdiction, its judges are afforded, quote, great deference, end quote, in ruling on a petition for rehearing, and the exercise of their discretion should be given, quote, great deference, end quote. The department did not make up that standard. It is precedential case law. This is particularly true when the discretion is exercised in favor of granting a rehearing. Jimenez versus Sears, Roebuck and Company, 1971, 4 Cal 3D 379, pin site 387. The California Supreme Court held that, quote, so long as a reasonable or even fairly debatable justification under the law is shown for the order granting the new trial, the order will not be set aside, end quote. Jimenez at page 387. The deference to Panel 2's decision is so strong that the order granting the rehearing must be affirmed if it should have been granted on any grounds stated in the department's petition, regardless of whether Panel 2 specified that ground, and even if it failed to specify any grounds. See Christian v. Bowles, 1970, 7 Cal App 3D 480, pin site 415. See also Rickley versus County of Los Angeles, 2004, 114 Cal App 4th, 1002, pin site 1008. The burden is on appellant to show a manifest and unmistakable abuse of discretion by Panel 2. See Jimenez at page 387, and People on behalf of the Department of Public Works v. Hunt, 1969, 2 Cal App 3D 158, page 1, pin site 163. Absent such a showing, the order may not be set aside, and the rehearing must proceed. Appellant has repeatedly cited to an error of law and seems to use the term interchangeably with contrary to law, but they are not the same. For example, at the pre-hearing conference, appellant cited to Stoddard v. Ream, which is a 1961 case, 192 Cal App 2D 49. That case concerns judicial review of a new trial order based on an error of law, which is different grounds for rehearing than the one in this case. Regulation 30604B clarifies that while the contrary to law standard of review involves a review of the Panel 1 opinion for consistency with the law, which is the grounds the department argued and Panel 2 found, a review for an error in law involves a procedural error in the proceeding and provides an example of the erroneous admission of evidence subject to attorney-client privilege. This was clearly not the basis for this petition for rehearing. Therefore, that case is irrelevant. All presumptions are in favor of the order granting a rehearing. See Christian v. Bowles at page 415. Thus, the rehearing was properly granted. The original opinion was contrary to law, and that it was in direct conflict with Revenue and Taxation Code sections 6009 and 6009.1 and precedential case law for the reasons outlined in the department's petition for rehearing, specifically the following cases. And bear with me as I read them. I'll only read the full citations once. Parfums Corday Incorporated versus State Board of Equalization, 1986, 187 Cal App 3D 630. Yamaha Corporation of America versus State Board of Equalization, 1999, 73 Cal App 4th 338, what we will refer to as Yamaha 2. Stockton Kenworth Incorporated versus State Board of Equalization, 1984, 157 Cal App 3D 334. H.J. Heinz Company versus State Board of Equalization, 1962, 209 Cal App 2D 1. And Wallace Berry and Company versus State Board of Equalization, 1985, 40 Cal 3D 60. Panel 3 has also asked the parties to address what degree of deference, if any, it owes to Panel 1. By law, the Panel 1 decision is entitled to no deference. The facts of this case are not in dispute, and the issues on rehearing are predominantly questions of law. When proceeding after a petition for rehearing, questions of law and mixed questions of law and fact that are predominantly legal are subject to de novo review. TRC Operating Company Incorporated versus Chevron USA Incorporated, 2024, 102 Cal App 5th, 1040, pin site 1063 to 1066. Nothing in the opinion on petition for rehearing or OTA's rules for tax appeals limits the rehearing, and the rules for tax appeals permits an opinion on rehearing to supersede the original opinion in whole. See Regulation 30607H. De novo review means that the current panel should not defer to Panel 1's ruling or reasoning, but should decide the matter anew without deference to the Panel 1 opinion. See Stone Street Capital, LLC versus California State Lottery Commission, 2008, 165 Cal App 4th, 109, pin site 116. Deciding this case de novo would also mean that Panel 3 does not need to afford deference to Panel 2's reasoning, aside from the deference it should afford its decision to grant the rehearing. The Starbuzz case, which appellant references, is not precedential and is easily distinguishable, as it does not apply to the standard of review to be used in a properly granted opinion on rehearing, which is what occurred in this case. Which brings us to the primary issue: whether the measure of appellant's unreported inventory withdrawals of testing supplies during the liability period should be reduced, entitling appellant to a refund. The answer is no. The measure should not be reduced, and appellant is not entitled to a refund. There was a taxable use of the testing supplies in California. Appellant purchased the TPP at issue ex-tax via resale certificates with no intention of reselling them. Appellant stored the TPP in its California warehouse. And appellant consumed the TPP when appellant withdrew the TPP from its resale inventory and shipped it via common carrier to patients and trainers in fulfillment of its contracts. Any one of these actions is a taxable use, meaning appellant is not entitled to a refund for use tax paid. We will begin with appellant's purchase of the TPP via resale certificates. Panel 1 found, and appellant does not dispute, that appellant purchased the testing supplies ex-tax, meaning without payment of tax or tax reimbursement. Panel 1 raised the issue in the original opinion as to whether appellant purchased the TPP at issue, quote, ex-tax via issuance of resale certificate, end quote. But it declined to make a factual finding as to that point, despite the evidence before Panel 1 containing a written admission by Jonathan Lay, the senior tax manager of corporate tax employed by Abbott Laboratories, the corporate parent of appellant, that appellant purchased the TPP, quote, as inventory supplies ex-tax under a resale certificate, end quote. Exhibit E, page 1868. Mr. Lay then explained that appellant removed the TPP from resale inventory when shipping it to patients as part of its testing services. As previously stated, mixed questions of law and fact that are predominantly legal are still subject to de novo review, and we request that Panel 3 make a factual finding as to this point. This is not a new issue, since it directly relates to the issue of whether the measure of appellant's unreported inventory withdrawals should be reduced. And it's not a new legal theory, as appellant claimed in its written objections, as it was raised by Panel 1 in the original opinion. See original opinion, page 9, footnote 12, and page 11, footnote 16. It was raised by them twice. Regulation 1668G states that a purchaser who issues a resale certificate who, quote, thereafter makes any storage or use of the property other than retention, demonstration, or display while holding it for sale in the regular course of business is liable for use tax on the cost of the property, end quote. The tax is due when the property is first stored or used. Therefore, appellant owes use tax for its storage and use of the TPP in California. Furthermore, appellant purchased all its testing supplies ex-tax via resale certificate, but in fact, only resold an average of 9% of those purchases. Exhibit I. Now, we pause here to note that in the department's April 15th, 2026 reply brief, we describe how Exhibit I was compiled. The department analyzed the total cost of goods sold for all testing supplies from appellant's general ledger accounts and compared it to the testing supplies self-consumed. All of the information used in the analysis was obtained from appellant during the audit, and we have gone so far as to include the original files received from appellant as Exhibit J. We are frankly baffled that appellant would object to its own information that it submitted to us, which is why we did not anticipate there to be a factual dispute. So, appellant purchased all its testing supplies ex-tax via resale certificate, but in fact, only resold an average of 9% of those purchases. Of the remaining 91% of the testing supplies appellant did not resell, it intended and did ship 94% out of state in non-retail transactions. See appellant's response brief, June 8th, 2023, pages 4 and 16 to 17. The other 6% of the self-consumed supplies were sent to in-state patients, for which appellant appropriately reported use tax for part of the liability period. See response brief, page 4, and Exhibit E, page 131. This means that while appellant purchased 100% of the testing supplies via resale certificates, It only paid use tax on less than 15% and never paid any tax on 85.5% of the TPP. Taxpayers may not issue a resale certificate to purchase property in this state for the purpose of transporting the property outside the state and claiming the exemption from use provided by Section 6009.1, because purchases of items in California via a resale certificate known at the time of purchase to be for out-of-state use are not covered by the exclusion. See Regulations 1668D and annotations 475.0159, 475.0073, 570.0435, and 315.0308. Issuing a resale certificate to create a use tax exclusion under Section 6009.1 is a misuse of the certificate when it cannot be realistically said that the TPP was purchased for resale in the regular course of business. Given the facts of this case, appellant can hardly claim it did not know whether the TPP at issue would be resold or used. Thus, appellant's attempt to claim a use tax exclusion under Section 6009.1 was a misuse of the resale certificates, and its purchases are subject to tax. While the department did not seek to impose the penalties relayed in Regulation 1668D for improper use of a resale certificate during the liability period, this evidence provides yet another basis on which appellant owes use tax and should be barred from claiming the Section 6009.1 exclusion. When sales tax does not apply, use tax applies to the storage, use, or other consumption of TPP purchased from any retailer for storage, use, or other consumption in California, measured by the sales price, unless the use is specifically exempt or excluded by statute. Revenue and Taxation Code sections 6201 and 6401. The use tax is imposed on the person who stores, uses, or otherwise consumes the TPP, section 6202. Storage includes any keeping or retention in California for any purpose except sale in the regular course of business or subsequent use solely outside the state, section 6008. As established, appellants stored the TPP in California before shipping it to patients and trainers in non-retail transactions. Therefore, appellant's storage was not for sale in the regular course of business, nor was it used solely outside the state, and was a taxable use. Use includes the exercise of any right or power over TPP incident to the ownership of that property, except sale in the regular course of business, section 6009. Any exercise of rights incident to ownership, otherwise known as a taxable use, include title passage in California in non-retail transactions. See Yamaha 2. See also annotations 280.0040, 280.1140, 570.0035, 280.0390, 570.0037, 315.0766, 570.0435. This has been the department's interpretation for over 60 years. This interpretation should be entitled to great weight as, quote, an agency's consistent maintenance of the interpretation under scrutiny, especially if it is long-standing, is a circumstance which weighs in favor of judicial deference, end quote. See Yamaha 2 at page 352, internal quotations omitted. In fact, the Court of Appeal in Yamaha 2 specifically examined annotations supporting the department's position, annotations 280.0040 and 280.1140, and found the department's interpretation was entitled to great weight. Yamaha 2 at pages 351 to 354. The department has not found any legal authority, nor has there been any presented by appellant or panel 1, in which title passage in California in a non-retail transaction was analyzed and found to be anything other than a taxable use. In briefing, appellants, and also in the original opinion, panel 1, cited to Stockton Kenworth for the proposition that out-of-state transport pursuant to a contractual requirement did not constitute taxable use. However, that is an overbroad misstatement of the holding, as the ownership in Stockton Kenworth remained with the lesser purchaser, which then transported the property out of state by its own means and used the property out of state when it transferred possession of the trucks to the lessees outside California. Panel 1's interpretation and application of Stockton Kenworth is one example of where the original opinion was contrary to law. See original opinion, page 9. In both retail and non-retail transactions, title to the TPP passes upon delivery to a common carrier unless otherwise specified. See Yamaha 2 at pages 354 to 355. See also annotation 495.0625. Appellant did not present any evidence that there was an otherwise specified occasion of title passage. Here the department determined appellant made taxable use of the TPP at issue when it withdrew the testing supplies from its resale inventory for out-of-state shipment by common carriers in fulfillment of its Medicare contracts. Upon shipping the testing supplies, appellant relinquished title and possession to the TPP, and it was consumed by appellant in rendering its contractual obligation to provide the TPP. Appellants have argued that its use of the TPP comes within the Section 6009.1 exclusion. 6009.1 states that the terms storage and use do not include keeping, retaining, or exercising any right or power over TPP for the purpose of subsequently transporting it out of state for use thereafter solely outside the state. Exemptions and exclusions are strictly construed against the taxpayer. An appellant bears the burden of proving and providing some credible evidence of entitlement to the exclusion. Appeal of Snowflake Factory, LLC, 2020-OTA-270P. Appeal of Owens Brockway Glass Container Incorporated, 2019-OTA-158P. Appellant's burden requires proof by a preponderance of the evidence, Regulation 30219B. That is, appellant must establish by documentation or other evidence that the circumstances it asserts are more likely than not to be correct. Appeal of AMG Care Collective, 2020-OTA-173P. Unsupported assertions are not sufficient to satisfy appellant's burden of proof. Appeal of Amaya, 2021-OTA-328P. Appellant has not provided any legal basis or corresponding credible evidence that would make Section 6009.1 applicable in this case. For nearly 70 years, 69 to be exact, the department has given taxpayers notice of its interpretation that Section 6009.1 is only applicable in cases where a purchaser has stored property in California and then transported it outside the state for that purchaser's own use, whether that use be subsequent title transfer or some other use. See, for example, annotations 570.1100, 570.1140, 570.1121, 570.0438, and annotations 280.0390, backup letter at page 3, and 570.0435, backup letter at page 1. In briefing, appellant argued for a plain language interpretation of Section 6009.1. However, when interpreting any statute, the Supreme Court has stated that a tribunal's goal should be to determine the legislature's intent and give effect to the statute's purpose, beginning with the language of the relevant position and considering it in its statutory context. Ioff versus Linnell, wait, how do I say this? Is that a P? Okay. Ioff versus LaPaille, 2025, 18 Cal 5th, 551, pin site 560. The department's interpretation of Section 6009.1 is consistent with the statutory scheme. As already stated, Section 6009 defines use to include the exercise of any right or power over TPP incident to ownership of the property, and title transfer in California in a non-retail transaction has been recognized by the courts as a taxable use. See, for example, Yamaha 2 at page 357. This is because, as the court found in Wallace-Berry, quote, transfer of the goods other than by sale in the regular course of business is, almost by definition, use, end quote. Wallace-Berry at pages 62 and 68. When read in the context of the statutory scheme, a purchaser's non-retail transfer of TPP in California, again, a taxable use pursuant to Section 6009, is disruptive to the application of Section 6009.1, since the purchaser's use would not be solely outside the state, as required by statute. Therefore, Section 6009.1 only applies when a purchaser transports the property outside of the state for their own use. The department's interpretation of Section 6009.1 is uncontroverted by the legislature. Section 6009.1 has been amended twice since the 1957 issuance of Annotation 570.1100, once in 1965 and again in 1980. The amendments did nothing to suggest that the legislature disagreed with the department's interpretation of the statute, and the court in Yamaha 2 presumed that the legislature, quote, is aware of a consistent and very long-standing administrative interpretation, and thus the reenactment of the statute being interpreted with no modification is a strong indication that the administrative practice was and is consistent with underlying legislative intent, end quote. Yamaha 2 at pages 353 to 354, citing 6 other cases for that principle. The department's interpretation of Section 6009.1 is uncontradicted by case law. Appellant has not provided a single case in which Section 6009.1 was found to apply to transportation of TPP out of state for the sole use of someone other than the original purchaser, or explained how appellant's title transfer within the state constitutes use solely outside the state as required by statute, or provided any evidence that title transferred outside the state. Appellant has argued, and Panel 2 incorrectly suggested, that OTA should consider the first functional use, which appellant has been calling actual use today, which occurred out of state. Regulation 1620 states that TPP purchased outside of California, which is then brought into this state, is regarded as having been purchased for use in this state if the first functional use of the property is in California. Regulation 1620b3. For purposes of Regulation 1620, functional use is defined as use for the purposes for which the property was designed. However, first functional use of the testing supplies at issue is irrelevant. Even if the supplies were first functionally used outside of California, Regulation 1620b3 does not preclude the imposition of use tax if the TPP was otherwise first stored, used, or consumed when located in California. In fact, Regulation 1620B states that, quote, use tax applies to the use of any property purchased for storage, use, or other consumption and subsequently stored, used, or consumed in this state, end quote. Functional use is not the only metric by which TPP may be used for use tax purposes, nor is unqualified first functional use outside California a general use tax exclusion. This is clear from a basic reading of Regulation 1620 and has been supported substantially by case law. In Yamaha 2, the court rejected the taxpayer's argument that it made no functional use of the TPP, stating that a gift is, quote, subject to use tax if the gift is made in California, whether or not a functional use of any other kind is made of the property, end quote. Yamaha 2 at page 356. In Atchison, Topeka, and Santa Fe Railroad Company versus State Board of Equalization, 1955, 131 Cal App 2D 677, pages 681 to 82, the court rejected the taxpayer's argument that the time and place of the functional use of the TPP should be considered, stating, quote, inasmuch as Section 6009.1 requires exclusive use outside the state, the functional use is irrelevant, end quote. The court concluded that when Section 6009.1 was enacted, quote, the exemption was not worded to exempt property subsequently used in interstate commerce, but only exempted property thereafter used solely outside the state, end quote. In American Airlines Incorporated versus State Board of Equalization, 1963, 216 Cal App 2D 180, pin site 192 to 193, the court rejected the taxpayer's argument that because the TPP was substantially consumed outside California, this should exempt its use in the state, finding that it was, quote, not particularly concerned with the ultimate consumption of the property, end quote, as it, quote, makes little difference, end quote, when a taxable use already occurred in this state. It further concluded that if the legislature intended substantial use outside the state to be sufficient in exempting the property from tax, it would have done so, citing Section 6009.1 and the requirement that the TPP be used solely outside the state. It is worth noting that when TPP has already been committed to a taxable use inside California, as the TPP had been here, courts have considered both functional use by a third party, in the case of Yamaha 2, as well as the taxpayer's own functional use outside the state, in the cases of Atchison, Topeka, and Santa Fe, and American Airlines, to be insufficient in exempting the TPP from use tax. Regardless, appellant has not met its burden and supplied an actual legal basis or corresponding credible evidence on which to claim the patient's functional use of the testing supplies as its own. And while appellant insists that the testing meters to which it retained title, and it did so in briefing, cannot be used without the testing supplies, that fact is irrelevant in determining whether appellant had already used the TPP in California in fulfillment of its service contracts. It is also irrelevant in determining some sort of proxy use on the appellant's behalf. Finally, Panel 3 inquired as to whether appellant reported or paid tax to any other state with respect to testing supplies shipped to out-of-state patients in 2014 and 2015. Appellant has not presented any evidence on this matter or even shown a likely risk of multiple taxation. And even if appellant did present evidence it paid tax on the TPP out of state, the court has held that payment of California use tax in instances where the TPP was purchased without payment of sales tax, which is what occurred in this case, it will not result in unconstitutional multiple taxation due to reciprocal credits granted by member states of the Multi-State Tax Compact and California's Section 6406 statutory credit against tax paid in another state. See Yamaha 2 at pages 368 to 369. We also note that other states provide similar statutory credits, which were outlined in the November 12, 2021 Appeals Bureau decision, Exhibit A, pages 17 to 18. But again, appellant has not presented any evidence on this matter. Appellant also claims that the department's annotations are underground regulations. However, appellant is wrong to classify them as such because the Administrative Procedures Act does not apply to legal rulings of counsel issued by the department, and annotations are summaries of the conclusions reached in legal rulings of counsel. Government Code Section 11340.9b and Regulation 35101A1. Because annotations are restatements of legal rulings of counsel, which are expressly exempt from the APA, they are not underground regulations, citing to those same two sections, as well as the fact that they give notice to taxpayers on the department's interpretation. Finally, a plain and good reason exists for finding use tax is due in this case. Because if it is not, appellant will, quote, escape paying tax on the subject property, the precise result which the use tax statutes were enacted to prevent, end quote. Yamaha 2 at pages 354 to 355. Again, appellant purchased 100% of the TPP at issue, ex-tax, and never paid any tax on 85.5% of it. To find for appellant results in appellant's purchase and use benefiting from an inequitable escape from taxation, which the courts have found is inexcusable. See Yamaha 2 at page 348 and 364 to 365, and Wallace-Berry at page 667. In conclusion, the rehearing was properly granted, and the law requires that this panel afford Panel 2's decision to grant a rehearing great deference, and Panel 1's decision in entirety no deference. Appellant purchased the TPP at issue ex-tax via resale certificates with no intention of reselling them. Appellant stored the TPP in its California warehouse. Appellant consumed the TPP when it withdrew the TPP from its resale inventory and shipped it via common carrier to patients in fulfillment of its contracts. Any one of these actions is a taxable use, meaning that the taxable measure should not be reduced and appellant is not entitled to a refund. Thank you.
Thank you, CDTFA. You have 3.5 minutes. All right, I will now turn to my co-panelists to see if they have any questions for CDTFA, starting with Judge Turner.
Yep, I want to start out with a similar question I asked appellant, which is on the review of the PFR opinion 2. I believe it's the department's position that we should give a significant amount of deference to the opinion, but that we ought not to give a similar deference, or maybe it's that panel should not have given a similar level of deference to the underlying opinion. And I'm trying to get to the same question I asked appellants, which is, in our review of the PFR, is it different, our consideration of that second panel's opinion, is it different than that panel's determination or review of the underlying opinion?
I think I understand your question, and I do think it is different. So the court cases say that when reviewing a motion for new trial, or in this case, we'll apply that case law to a petition for rehearing, that panel's decision to grant the rehearing is entitled great deference. So if they granted it, even if they didn't state why, or even if their statements were incorrect, if you were to find that the fact that they found that the opinion was contrary to law means that their decision to grant a rehearing stands. So
Okay, I think I understand your point. Let me see if I can summarize it correctly, which is, if they've made if that second panel made a determination that the first opinion was contrary to law, even if we might disagree with that particular conclusion, we are still to give great deference to that conclusion that second panel reaches. Is that right?
That's correct. Absent a showing of unmistakable, let me find the quote. It's, yeah, an unmistakable abuse of discretion. So unless you found that, which nobody has claimed, and couldn't claim, frankly, then that decision to grant the rehearing must stand.
Got it. Okay. Moving on to substantive questions. Does the department dispute the taxpayer's assertion that their contracts require that they provide these lancets, if I'm describing them correctly, to out-of-state customers that are the, I guess, beneficiaries of those insurance contracts? Do you dispute that?
That they're required to provide the test strips?
Mm-hmm.
I wouldn't, no, we don't dispute that. That would be why them shipping them in fulfillment of those contracts makes it their own consumption and use, taxable use.
So if I understand that correctly, then what you're saying is that the mere transfer, what you're saying is title transfer on the delivery of the product to the common carrier, that constitutes the taxable use.
Because they're consuming it in fulfillment of those contracts. Their consumption, they obviously, Alere cannot consume the TPP functionally, but they consume it by, that their only use of the TPP could be their provision of it in.
But isn't the premise of Yamaha too, that the gift that the court found was a taxable use was an independent transaction, right? Isn't that what we're arguing here? Is that if it's a single transaction, your annotation that you're citing to doesn't even apply because it talks about an other transaction. Is that not right?
I guess I'm not understanding your question. I'm sorry.
It's all right. Wouldn't be the first time someone's been confused by my questions. So let me ask this. So a taxpayer manufactures, prints, and purchases for resale, business forms and supplies. So they purchased something or they've made something and they're holding it in inventory for resale. If a shipment's made from the California warehouse to a customer's location outside the state and the contract specifically requires delivery to the out-of-state location, which seems like the facts here have suggested it is it not?
We wouldn't say that this is a delivery contract. We haven't been given any evidence that they have a contract for services. The services includes provision of supplies, but there's no contract provisions that show that title transfer would occur outside the state.
But you just said that they're obligated under that contract to provide these lancets.
Just because they're obligated to provide it doesn't make it a delivery upon receipt contract.
Explain to me the difference.
So we would say that, and let me.
Is it because title passes in the state?
Our title passes in the state as is de facto, like that's what happens unless specifically stated. Do you want to jump in? Maybe I'm not.
No, I think that is correct. The department's position would be that title, absent a title transfer clause in the contract, an explicit title transfer clause, that title would transfer upon delivery of the product to a common carrier in California. And it's the department's position or understanding that there isn't a specific title transfer clause, despite perhaps the contract requiring delivery Obviously, the contract is going to have to require delivery of the testing supplies. Otherwise, there wouldn't be a purpose of having the contract.
Isn't that what we just established, though? That the facts suggest, or the facts indicate, and I didn't think you objected to it, which is that the contracts at issue here, which they're a service contract, but they're a service contract that also require the transfer of tangible personal property. If we've established that fact, then how is that contract not require the delivery of the TPP?
Not that it doesn't require it, but that it doesn't specifically state that title transfers upon delivery of the product. So that would be the department's position that.
So let me finish my summary then. If the shipment's made from a California warehouse to a customer's location outside the state, and the contract specifically requires delivery to that out-of-state location, which maybe you're still disputing that, but I think that's what we've established, is that the contract requires delivery.
There's no provision in the contract that we found that shows that delivery is required. We wouldn't, I mean,
The supply, okay, that's fine. I'll take that. So then, but the last part, the tax will not apply even though title may have passed in California. And what I'm reading from is your annotation 325.0010. And I'm not sure how to distinguish it from the facts that we have before us. Even if we assume that title passes in California, and we'll get to what title passage means, I'm not sure how to distinguish this annotation from the one you cite as, and the PFR opinion decided by panel number 2 cites as controlling that should have been provided deference. How do you distinguish those two?
the department has held that when a contract does not contain a specific title provision, but the TPP is shipped via a common carrier, title passes when the TPP is placed with a common carrier, which is what occurred here. So
Sure, but that's, I think your citation to that traditional treatment, A, presumes what title is, but B, assumes it's an independent transaction, right? What we're not talking about here is a independent sales transaction. This isn't a sale, at least if I understand what you've indicated before, is that there is a contract that requires the appellant to deliver this good to the customer, if you will, the user of their machine, the insured, if you will. That's your contract. Whereas I think what you're talking about is where there is a contract for sale and there's arguably a title transfer in California for shipment, that's a different transaction, I think, than what we're looking at here, is it not?
we would not say that these were sales, that's correct. I'm unclear as to what, how it being a non-independent transaction would somehow shift delivery upon receipt when it's not specifically specified by contract to be then what's been occurring. Because even in those sales transactions, delivery is required.
Annotation 50, the 570.0435 that we are dancing around says, storage use or other storage or use includes, but is not limited to, A, for functional use. I skipped over some language, but I'm getting to the fun part. For functional use in the state by the purchaser, we know that's not applicable here, and for the transfer of title in this state to other persons in transactions that do not constitute sales.
I'm sorry, can you direct me again? I know you've repeated it
okay.
multiple times to that specific annotation so I can follow along.
Annotation 570.0435, second paragraph. Storage or use includes but is not limited to a functional use in the state by the purchaser. We know that's not applicable here. And for the transfer of title in this state to other persons in transactions that do not constitute sales. Who are other persons? If we have a contract that requires the appellant to supply tangible personal property, are they other persons?
And this annotation,
Isn't that the one you're relying on?
yeah, this annotation somehow states that delivery is where TPP is transferred?
I'm just reading from it. It says, storage or use includes, but is not limited to, the withdrawal of property from resale inventory or other ex-tax inventory, such as property purchase from outside California, for functional use in this state by the purchaser, and for the transfer of title in this state to other persons in transactions that do not constitute sales. Other persons presumably is an other contract and other use. In the context of Yamaha, you would say it's the gift to an unrelated party, but here other persons presumably are the Lancet consumers, but they're not other persons, are they? If you agree that appellant has to, under contract, supply goods to these insureds outside the state, that's part of an existing contract. They're not other persons. They're the parties that they're obligated to provide the TPP to. So I'm not even sure how your regulation that you're intending to, you're saying controls, not only that it was the reason why opinion 1 was decided improperly, but is the basis upon which the PFR was granted, how that's applying here. If you agree that there's a contract that obligates the appellant to provide this tangible property.
I'm so sorry.
okay.
It seems like we're not understanding your question, or it seems like we're not connecting. If you'd like us to brief this post-hearing, we'd be happy to do that. We're not entirely sure. It doesn't seem like we're disagreeing. I read that section of the annotation, storage or use includes withdrawal of the property from resale inventory or other ex-tax inventory.
Maybe we'll move on to this. So 16, I think you actually mentioned it. I just want to make sure I understand. Regulation 1620 generally defines the taxable use, right? It's not any use that triggers taxation, all right? It's a taxable use, right? And so, and the courts have looked at that in different contexts. Yamaha said that a gift was a taxable use. Regulation 1620, though, seems to structure what constitutes taxable use in the context of its functional use, right? It's first functional use. Did I understand correctly? You said that that's different when we're talking about purchases from outside the state for property brought into the state. Use there goes to the first functional use. But here, where we're talking about the transfer of property from California to out of state, a different rule applies. Did I understand that correctly?
We would say that first functional use is irrelevant in this case, because first functional use, while it can be a metric to define whether use occurred in California, it's not the only metric to define taxable use.
Isn't that how Regulation 1620 defines what a taxable use is as a first functional use?
First functional use is a type of taxable use, but it's not the only type of taxable use, which, as those cases that I cited to, Atchison, Topeka, Santa Fe, Yamaha, there was another one, American Airlines, first functional use is not the only use that's relevant when determining taxable use.
So if I think I get that correctly, the mere transfer of title in the state constitutes a taxable use. Is that what I understand?
That it
Could a retailer ever export goods they purchase ex-tax?
I'm sorry, that's not our
Well, we
that's not
typically
our
have-
facts today.
No, actually it is, because
what we're asking is, your argument is that the assuming title transfers in California, that mere taking of property out of inventory and giving it to a common carrier go ahead, yeah.
Well,
what am I missing?
they purchased the property. They
Ex-tax.
they didn't
Correct.
create the property.
Is there a distinction?
They purchased it ex-tax. It's not, you were saying a retailer,
Well, I think in my facts, the retailer both manufactures their own and purchases for resale, so it was both. Either way, they have ex-tax inventory, right? They have product that they are going to resell that's ex-tax. That was from the annotation. It was both purchase and manufacture of their own. But my question is, though, that if I'm a seller and I'm selling tangible personal property all over the country, typically, if I'm selling to purchasers in other states, that sale is exempt, right? That's 6396. It's a sales tax exemption. But now what you're telling me, though, is you're taking the product out of inventory, right, and giving it to a common carrier, the transfer of title constitutes a taxable use, which means that exemption for sales and interstate commerce just got eliminated. And I'm trying to understand the distinction, why you think that's not happening.
because these aren't sales.
Why aren't they not sales?
They're not sales because this is not a,
Because it's part of a contract.
well, no, they're not sales because it's not an exchange of TPP for consideration.
But I thought you said earlier that you agreed to the factual assertion by the taxpayer that they are obligated under a contract to provide it. It may be a services contract, but they have a contract that requires them to provide this tangible personal property. Don't they?
But it's still not a legal sale. We defined it in briefing, but this isn't a transfer of TPP for consideration. It's a legal gift. We defined it in our briefing.
Okay. So your position is that see if I understand it correctly. Your position is that the taxpayer's provision of Lancets constitutes a gift of tangible personal property. Is that right? So let me see if I get this right.
A legal gift.
Because the consequences of that are, if I have a service contract, right, that requires me to provide tangible personal property, but we know the true object, we've made that determination, the true object of that transaction is a services contract. You're saying essentially any provision of tangible personal property as part of a service contract constitutes a gift. Is that what I understand?
I don't know that we would say any. It would depend on the facts. And so if we're talking
would be
about the facts
what
of this case, and we're not going to engage in hypotheticals in this setting. If you would like us to brief it, if you have specific questions that you want us to brief, and we can research and take the time to answer it more fully, then we would be happy to do so.
Just trying to run through your arguments. What's title?
If you're asking for the legal definition of title, I don't have it in front of me. We're happy to brief it.
Well, no, we've made the assertion that title is transferring in California on the mere placing of property in the hands of a common carrier. I want to know what title is. We know what that is. That actually happening here? Taxpayer has at least suggested by testimony that the risk of loss doesn't pass until property's in the hands of the customer, or the recipient, I guess we'll call them. And so my question is, what's title? How am I supposed to, or are we supposed to figure out whether title actually passed? We've been talking and saying that title passed, but
risk of loss is not risk of loss an element of what constitutes title?
We've been talking about both title and possession, and in this case, taxpayer has relinquished their possession of the TPP when they transferred it to a common carrier.
What is title other than possession?
Again, I don't have the legal definition.
Fair enough. One more question, annotations. We've talked a little bit about, and I think in the department's testimony, you testified that the annotation constituted the summary, but I think you also referenced in reliance on annotations as the rulings of counsel as the backup. Are they different? Is it one and the same? If we're talking about, we know that for a rule of general application, which I think we'd all admit that these are, in order for them to be exempt from the Administrative Procedures Act, right, they have to be legal rulings of counsel. And so we often cite whether it's the summary or maybe the backup, maybe it's both, I don't know. I'm trying to understand the department's position on what is the annotation. Is it both? Is it the summary? Are we to rely solely on the summary and not the backup, or are we to rely on the backup and not the summary, or both?
So annotations are defined by the government code, and the APA says that legal rulings of counsel are not subject to the APA. Now, there's been court cases that give deference to annotations. Annotations are summaries of the legal rulings of counsel. We would say that we've not been presented with a case where they would be different, so I guess we would say both.
Fair. Okay. That's all I wanted to know. Thank you. That's all my questions.
All right, thanks. I'm going to jump in here because I wanted to follow up on a thread of Judge Turner's questions. So you had made the argument, and you'd step through you had described the transaction with respect to the supplies, and you had mentioned that at various points that constituted taxable use. Could you contrast that with the meters, which CDTFA did not assess? It seems that up to a certain point, it followed the same steps, but you didn't assess use tax with respect to the meters. And I was just wondering what was different about that transaction as opposed to the supplies.
Yeah, so appellant retained title to the meters, which the patients returned to appellant when they were no longer needed. So the fact that appellant received the meters again and retained title to them meant that we did not assess use tax on those.
So the key is title transfer. It happened in one case and it did not happen in the other case. Okay.
Correct.
Judge Long, any questions?
I do have a few questions regarding annotations. I just want to verify the position with regard to, so first, annotations are not the law, correct?
Correct.
Okay. But in this case, it appears to be CDTFA's position that based on the length of time that this annotation, particularly the two discussed today, the 1992 and 1995 annotations, based on their length of time and also the apparent acquiescence of the legislature, they've essentially gained the force of law?
We wouldn't say they've gained the force of law. They've just been entitled to deference.
Okay. And
we, sorry to interrupt you, we cite to more annotations than just those two annotations. We have a very robust history of interpreting section 6009.1 in this way because it makes sense in context of the whole statutory scheme.
Sure, I understand, but the PFR specifically discusses the annotation for 570.0435, right? So that's why I am concerned with it. I do want to also just clarify, restatements of council decisions are not underground regulations. Is that CDTFA's position?
That's correct.
And in this case, in the case of 570.0435, this consists of, is a restatement of council decision largely because it's a digest of these other annotations that are cited within? Because this annotation bases itself on like 12 other annotations. Is that the restatement of council decision that we're discussing here?
The annotations that it's based on are legal rulings of council. We don't have any particular need for that. I mean, that specific annotation and all the department's annotations are entitled to deference in so much as they all purport the same thing, which is that section 6009.1 only applies to the purchaser's own use outside the state, and section 6009, title transfer is a taxable use.
Okay, thank you. I don't have any further questions.
Thank you. I just had one or two questions. Sorry, I know you didn't want to deal with hypotheticals, but I just want to present a hypothetical. So if appellant had taken the supplies, transferred it to a third-party shipper, and then shipped it out of state to itself, and so there's no title transfer, so in that case, 6009.1 would apply, and so that would be not taxable in California, is that correct?
The Stockton-Kenworth case, they transported the supplies, the trucks, by their own measure outside the state, and then transfer title outside of there. Because this isn't what's before us, we'd have to thoroughly research your question.
Right. So, yeah, the reason why is because I think based on the comparison or the contrast with the meters, in that case, title transfer, in this case, it didn't transfer. And so I think we've established that transfer of title is kind of a critical element. I'm just wondering whether the handing off to a third-party common carrier, is that also of importance?
The court in Yamaha too found it to be so.
Okay. Got it. All right. Thank you. That's all the questions I had. All right. We're going to turn it over for for rebuttal and closing to appellant. We have 15 minutes, but we are, yeah, if you could. So, please. Sure.
Your Honor, we're back, and you said we have 15 minutes, but if we can do it in less, that would be great. I think that's what we'll try to do. I think many of the panel questions have been very apt. I was interested in the admission.
Sorry, can you speak into the microphone, Mr. Anderson? Thank you.
I was interested in the admission just a moment ago in response to Judge Long's question that these annotations do not, this is the admission, do not gain the force of law merely by accumulation and citation over time, and that bears on the contrary to law standard.
counsel advanced a legal argument going way back to the top of the department's argument relating to Code of Civil Procedure 657, which is a standard applied to a trial judge in a superior court in granting a motion for new trial in a trial conducted by that judge. And even there, the cases say that, that the discretion that the judge has does not extend to granting a new trial based on an error of law. And counsel made an effort to distinguish between 30604 5, opinion is contrary to law, and 30604 6, which is an error of law in the appeals hearing or proceeding, but it is perfectly clear from the case law under section 657 that a judge does not have any discretion at all to grant a new trial based on an error of law if there is no error of law. And it is still the case, Your Honors, it is still the case that the department has not tried to defend the error of law analysis in Panel 2's decision, and I believe that's because it is indefensible. Now, with respect to title, it's conceded that the contracts required provision of test materials, and that's Exhibit 18, we cited it earlier, specifically requires provision of test materials and equipment for home INR monitoring to patients. That's Exhibit B to Exhibit 18, which is the Blue Shield of California representative contract. And we also cited, what was the exhibit number? We also cited earlier the exhibit with the HCPCS codes, the same one cited in Exhibit 18, G0249, which specifically includes the same language, provision of test materials and equipment for home INR monitoring. That's Exhibit 20. Those facts are just absolutely clear, absolutely established. And so counsel makes this curious argument that somehow we have not cited authority to establish that merely putting a box onto a truck to ship to a patient in the state of Washington or in Alabama or in New Jersey or wherever it might be, merely doing that, somehow they say, where is the authority that says it doesn't constitute use in California? And the answer to that question is 6009.1 says that does not constitute use in California. Regulation 1620 makes it clear that that's not functional use, that does not constitute use in California. Stockton, the Kenworth case, specifically considered that issue and says, no, that does not constitute. That was where the lessor is driving its own trucks, but they say that does not constitute use in California. I just want to, and it's so striking, Your Honors, that CDTFA tells you, counsel says this flat out, Panel 1 is entitled to no deference. That's what they said. Panel 1 is entitled to no deference. Their argument, taken to its logical conclusion, is that any case is subject to a do-over. And I don't think that that's the intention of OTA's rules, and I don't think OTA's rules can be stretched to say any such thing, but as soon as they strip the Panel 1 decision of any right to any deference, that's exactly where it puts you. Lastly, we've objected to Exhibit I and J. We objected on the basis that, yes, I I say again, this is a brand-new theory. Council referred to footnotes 12 and 16 in the Panel 1 decision, which reference resale certificate. The Panel 1 decision mentions that CDTFA never brought up resale certificate at any prior time. They noted that as a potential issue on their own motion in the course of reaching that decision. But what footnote 16 tells you, the very last sentence of footnote 16 says, in reaching the conclusion that an adjustment is warranted, this opinion makes no factual finding about whether the supplies were purchased ex-tax via issuance of a resale certificate. In other words, their finding with regard to an adjustment, with regard to a refund, is independent of any question relating to the resale certificate. That was not claimed at any time to have been an error of law. CDTFA made no effort at any time to put in the analysis Exhibit I or J as a way of challenging the Panel 1 decision at any time until the reply brief before this court, and we objected to on the basis, or we objected those exhibits on the basis that is 2 years too late to try to bring new evidence into this proceeding. If you look at Exhibit I, again, we've objected to it, and we don't think that you should consider it, but I just want to point out to you that there is a category of self-pay patients. Some percent, we don't agree with the percentage calculations here. We don't think that they've established how they've done it. This is coming entirely outside of the record. But even taking it for face value, those percentages, however low, indicate that some of these transactions are simply delivery pursuant to a direct contract with the patient, and those are all considered non-taxable. None of those are involved in this case. So the question is, why should insurance contracts be treated any differently? And the answer is they should not. The answer is that the insurance contracts require us to do exactly what we would do in a self-pay situation. The only difference is that the insurer is standing in the shoes of the insured in making the payments. I believe that is a sufficient answer. We think that this case. All right, and I wanted to let you go, but
Just a quick question. You had mentioned error in law as the grounds for rehearing, and CDTFA had noted that there was a distinction between error in law versus contrary to law. Did you mean contrary to law, or do you actually mean error in law?
So the 5 and 6 refer, the difference between 5 and 6, contrary to law versus an error of law in the OTA appeals hearing or proceeding, is a distinction that exists only within the OTA rule itself. What counsel is trying to suggest is that they could still rely on discretion under Code of Civil Procedure 657, the new trial procedure, which we say doesn't enter into this at all, shouldn't enter into this at all because of the radically different procedural settings between a trial judge granting a new trial and an OTA panel 2 looking at OTA panel 1 under this rule for a rehearing. But we made the argument that the case law under 657 grants the judge no discretion for granting a new trial on the basis of legal error. If there's going to be a new trial on the basis of legal error, that legal error has to be shown, and if it's not shown, the new trial is overturned by the Court of Appeal. That's what we're saying should be the rule here, whether 657 is directly applicable or not, because no legal error has been shown. I hope that's clear.
Now Judge Long has a question for you.
Yes, thank you, Your Honor.
Regarding the difference between the trial court rule and the OTA rule, is there any effect on the applicability of the trial court rule, whereas here the second panel's lead is the same as the first panel's lead?
That's a great question, and there is absolutely no analogy, and that's what's, frankly, that's what's wrong with looking to case law under Section 657. I mean, as my colleague points out, I spend a lot of time litigating cases in court. I know what a new trial motion is and isn't, and it's a motion address that you have a trial judge in charge of a trial. At the end of the trial, you don't like the result, so you move the court for a new trial, showing that there's some problem with the facts, some problem with the evidence, some problem with the conduct of the jury, some problem with this, some problem with that, and including legal or procedural error. What I'm suggesting to you here is that the legal error standard requires a court of appeal will look at that and say, we need to see the actual legal error. We can't just decide, Superior Court judge, that you just changed your mind and reversed yourself on a ruling that was not legally erroneous. That's not going to be a basis for a new trial. So the only thing that I can think of is it makes no sense to apply rules relating to new trial motions in Superior Court to an appellate situation, Office of Tax Appeals, where you've got multiple appellate panels in operation to hear cases. And it makes no sense to say what we want to do is we don't like what panel one did, so we're going to go down the hall and ask panel two if they'll fix it for us. There's no analogy, zero analogy to new trial motions in that setting. Maybe that answers your question.
Yes, thank you.
All right, thank you. And my colleague wanted to make a brief final argument.
Yes. Comment was made by counsel that, quote, the first functional use is irrelevant. And I find that to be very, very disturbing, because for our patients, the first functional use is the lancets and the strips into the meter. And 1620B 3, which we talked about, is where the tangible personal property, what it's designed for. This tangible personal property right here that we're talking about today was designed to be used by the patients and to be transmitted to the coag clinic. And we talked about it a little bit, but the coag clinic, this doesn't work unless it's the coag check excess system. It's all three. And we spent a lot of time in front of panel one talking about the fact, well, just because the meters aren't taxable, but that means then the supplies are taxable? No, it is one functional unit that works together, however the CDTFA wants to determine how it works. And the problem is that if the first functional unit use is irrelevant, then under Exhibit 18, the Blue Shield contract, where it says specifically provision of test materials and equipment, and the rate is $182.85 each, under HCPC code G0249, which is Exhibit 20, if if these materials are not functionally used, Alere doesn't get paid. It's that simple. So I had to point that out. Next item, the statement was made that the contract needs a title passing clause. Well, I mean, we're used to, in sales and use tax, a title passing clause. We all know that. We all grew up with that, whether we were at the BOE or CDTFA or the private sector. We all know that. But the reality is, in contracts such as this service contract, you're not going to have a title passing clause to these items. All that is cared about is the fact that these items are used together to find out whether warfarin is doing a number on a patient's blood and it's too thin or it's too thick. Either way, it could be life endangering. So title passage clause is irrelevant. I mean, we'd like to have it, I get that. But this is a service contract specifically. I'm glad the question was asked about the annotations. I think Leighton just hit that. But part of the problem is it's council rulings, and the question becomes, and I'm looking at annotation 570.0438, I'm going to talk about it in a minute. There's the annotation. It's 5 lines long, and there are 2 letters, May 7th, 1992, and then May almost a year later, February 5th, 1993, there's a second council. So those are the council rulings. If somehow those 2 make it into 5 sentences, let alone 12 other annotations, all of a sudden become the penumbra of council rulings, well, there is a question, I think, under the APA. And I don't think it's ever been discussed here at OTA, and I don't think it's been discussed previously. Because of the carve-out, everyone just assumes, well, if there's a council ruling, then therefore the annotation must be covered. I remember when annotations, some were council rulings, and many of them were determinations made by the audit staff in audit situations. They had nothing to do with council. Now, I don't know if those are still there or not, because we had the annotation project a couple of years ago at BOE and then CDTFA. So I think there's an issue relative to the annotations. And then the last thing is, it was brought up, and I put together a response. I'm not going to read it, but belatedly, there was brought up in the brief of the CDTFA about this new quote-unquote issue that Leighton, Mr. Anderson, just talked about. And that issue is, well, is there a appellant's purchase of testing supplies ex tax, resale certificate is inappropriate, that's barred, et cetera. That's a new issue, and I want to make sure it's clear for the record that the OTA rule is real clear on what it says about new issues, and that's Rule 30607B2, and it says non-filing parties opening brief that, B3, filing parties reply brief, it says that basically that there is to be no, they're going back to look at 30302, which is the general briefing schedule, which says very clearly in 30303C, appellant's reply brief, in this case, CGFA's reply brief, it says the appellant's reply brief, if submitted, may only address new facts, issues, or arguments raised in the respondent's opening brief. Our opening brief, we didn't say anything about resale certificates or anything. So they're requesting something that goes beyond what OTA's clear rule is. And we actually have, if I had to go to the actual merits of what they're saying, there's a series of annotations that say that if you pull something from resale inventory for use in California, he or she is liable for use tax measured by the cost of the property. However, where the property is consumed out of state, tax does not apply. Revenue Taxation Code Section 6009.1. That's based upon a legal counsel ruling that I'm holding in my hand here. And it says, it has now come to my attention that several years ago, we decided that where the taxpayer consumes the property out of state, at the time of purchase is unable to determine which items will be self-consumed and which resold, 6009.1 protects the withdrawal for out-of-state use from use tax liability. So the question there, of course, is where the taxpayer consumes the property out of state, and that's an issue that we've been talking about. But the point is that if it's going to go outside the state, and at the time you purchase it, you don't know whether you're going to be using it yourself or reselling or whatever the situation might be, you can go ahead and do that, but you'll have to self-accrue use tax when you use it in the state. The question is, what about outside the state? And this is the backup.
Mr.
February
Vinatieri,
5th,
you're up against
1993.
your time. If you could just finish up.
And so, just want to say thank you to the panel. I indicated when we began that there were a number of issues here. I mean, there's the issue of the 6009.1 and on its face what it says, and then there's another number of issues. So we know this has been a hard case for the department. It's been a hard case for us. It's a hard case for OTA. A third panel. This is rare that there's a third panel. So we just want to say thank you to the management, to this panel, the other panels, for taking the time. And we know that you're going to give this a great deal of thought because the issues here. And by the way, Leighton didn't say it, but our law firm was the one that handled Yamaha at the state Supreme Court and then back at the Court of Appeal. So we're very familiar with gift and annotations and title passage. So we just say thank you for taking the time to hear us here today.
Thank you. CDTFA, rebuttal and closing, you have 3.5 minutes.
We're open to ending the hearing.
Okay, thank you. So that, no closing? All right. I did have one follow-up question. When you had mentioned, with regards to my last hypothetical, you mentioned about Yamaha. I believe Yamaha, if I'm not mistaken, the taxpayer in that case transferred the instruments to a third-party common carrier who delivered it to the giftees out of state. My scenario was a little bit different. It was like the person who was gifting it in that case was gifting it to themselves. In between, they transferred it to a third-party common carrier. It arrived out of state, also to maybe an office of the giftor, and then that office transferred it out of state to the giftee. Does Yamaha apply in that case? Because I think the facts are a little different than Yamaha. In that case, there's no title transfer, but is the delivery of the tangible personal property to a third-party common carrier and delivered to out of state to itself, is that a taxable use in California with no title transfer?
We would want to first note those aren't the facts here, but we would
Right.
also say that there wouldn't be title transfer in that instance, so
There would be, or?
there would not be.
Okay, got it, okay. All right. For the last time, turning to my co-panelists. Any final questions, Judge Turner, for either party?
None from me, thank you.
Judge Long?
No further questions, thank you.
Okay. And then going back to the beginning of the hearing, I had mentioned the offer for additional briefing with respect to the standard of deference to be given by this panel to panel number 2. Are either party, they're okay with the briefings and their arguments as is with the sites and all that, starting with appellant?
We're satisfied with the argument we made, Your Honor. Thank you.
Great. CDTFA?
Only if OTA deems it necessary.
Okay, great. So that will conclude the hearing for today. The evidentiary record is closed. Well, the record is closed, and these cases are submitted. This case is submitted today. The panel will meet and decide the case based on the exhibits presented, and we will make a ruling on the objected exhibits I and J. And so we will base our opinion on definitely the admitted exhibits, and then we'll make a ruling on the contested exhibits. And then we will send the parties our written decision no later than 100 days from today. The oral hearing in this case is now adjourned. Appreciate both sides' presentations. And then the oral hearings will commence online tomorrow at 9 a.m. Thank you, everyone. Let's go off the record. It is 12:55. Thank you.